Then they quote Rameshwar Dayal, Chandra Mohan, and Satyanarayan, etc. They quote all that and kindly come to 608. Question number 8.3. Do you think that the officers in the lower judicial service should be allowed to compete for direct recruitment to the district judge cadre? If so, what should be the experience in service for such officers and how Article 233 of the Constitution of India should be amended? Explanation AA to sub-article so-and-so may be noted in this context. Then Your Lordship may skip the next few pages and come, Millets, to page 612. And please see, Millets, the paragraph 11.41, Constitution amendment proposed. Following amendment to Article 233(2) of the Constitution has been proposed. Then, Millets, they notice the stands of various high courts, Punjab Haryana High Court, Bombay High Court, the page over, Millets, Calcutta, Allahabad, Bihar, Judicial Service. All of them saying delete this word, add that, etc. All these suggestions are being given. And if Your Lordship will then come, Millets, to the final conclusion at page 617. 617, para 11.67. We accordingly suggest that clause 2 of Article 233 be substituted with the following clause. A person shall be eligible to be appointed directly as district judge if he has been for not less than 7 years an advocate or held judicial office in the territory of India and is recommended by the High Court for appointment. We propose so and so. Then 11.69 is important. We request the central government, all High Court, state government, administration unit to take immediate action for amending clause so and so as indicated by us. So, Millets, the clear understanding was that 233(2) as it stands does not permit Millets. And various high courts, Millets, all of them are suggesting various things, Millets, but this is the conclusion. This amendment is required. Yeah. Take too much time on that.
So interpretation as given to 233 in Satyanarayan Singh.
And Millets, Rameshwar Dayal and Chandra Mohan.
Absolutely.
And this, yes, Millets, of course, Millets. After referring to all of that, after referring, Millets, this is the interpretation. I agree with this. After referring to all the judgments, including Satyanarayan, of course.
Yes, in any case, these are recommendations.
I agree. I'm only trying to, Millets, even the debates, Millets, are not in any way, Millets.
Constituent Assembly debates are relevant for the purpose.
Of course, even this is relevant. Even this is relevant because Shetty Commission has proceeded on a premise. I'm not saying.
Judgments are based upon the recommendation of the Shetty Commission.
Yes, Millets, yes. Now, Millets, now kindly come back to my note, Millets. Millets, I have it thereafter, Millets, I have referred to Rameshwar Dayal and then Chandra Mohan at page, Millets, back in my submissions, Millets, page 48, 49 to the top of page 50. In volume 2 of my written submissions, Millets. Millets, should I now place Millets Rameshwar Dayal one more time, Millets, if
Yes,
yes, 1960. If Your Lordship will again take Rameshwar Dayal. Page 98 of the judgment volume. Volume 1, Millets, 5.1.
we have that.
5.1. Page 7. Well, I will just very briefly restate my understanding of Rameshwar Dayal. As I said yesterday, 233(1) and 2 both speak of appointments. 233(1) specifically uses the expression promotion. What the purport of that is, we will see. 230.
Postings also.
Posting also.
Also uses word posting. Appointment posting.
Yes.
So even direct appointing with an advocate, the source of appointment would be 233(1) only. Because after appointment, he will have to be posted.
Well, your lordships have
233(1)
interpreted.
deals with everything.
Otherwise, it will have a disastrous consequence. We'll tell you why. Because 233(1) says, the governor in consultation with the High Court. That applies to appointment and promotion and posting, everything. It can't be in piecemeal.
Well, your lordships have interpreted posting and promotion to mean that posting here refers to the first posting after promotion.
No, what about appointment?
Well,
After appointment, would not there be a first posting?
yes, Malas.
Or he's only appointed as a district judge in the state of Maharashtra. Is that sufficient?
No, Malas. Of course, Malas. My submission is this. Clause 1 is talking about promotion. Clause 2 is clearly referring to direct recruitment.
No. Clause 1 is also talking about appointment also.
Malas, yes, Malas, of course. Malas, I'm saying, Malas,
Then how is the appointment to be made for direct recruitment?
Malas, clause 2.
That's not under class 1 only, because governor in consultation with the High Court only, it can be done.
Yes,
You
Malas,
can't read it in piecemeal like this.
Malas, clause
Doesn't
2.
make any sense otherwise.
Clause 2 is also constitution. Clause 2 is also talking of appointment, Malas.
No, clause 2 says, for eligibility, is a recommendation should be there. Clause 1 says how an appointment should be made. Appointment should be made by the governor in consultation with the High Court. That applies when somebody is come on promotion, somebody comes on the direct recruit, thereafter the posting.
Let us see, Malas. Let us see. Let us see.
What we are tell you is that if your argument is accepted, if you remove you from class 1, how are you appointed then?
Malas, may I I'm not saying that, Malas. Kindly see 233(2) again. Person not already in service.
No, see 233(1) also.
Yes. Appointment of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state.
Correct.
Now, 2, a person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Now, Malas, my submission is that when 2 speaks of not already in service,
So that's also interpretation. It all depends in what way it
Now-
is to interpret it.
now, Malas, if
Because the placing of that would also be relevant.
yes, I agree, Malas. Now, my submission is Malas,
So your submission, you are right in submission.
my submission.
Your submission is 233(2) is exclusively meant for an advocate who has 7 years practice.
Now, if it were not so, the result will be that 1, we are reading into 2 what is not there. It does not specifically say this is for in service. It doesn't say that. So we are reading into 2 what is not there. Number 2, we are going to prescribe a qualification for them which is not there. Number 3, we are contemplating adding 3, 4, etc., which is not there.
Interpreted by Rameshwar Dayal and Chandra Mohan that Subarticle 2 provides a qualification for the persons who are already not in service. It provides a qualification for lawyers. If you are a lawyer, then you must have a 7 years practice. But it does not provide for a qualification insofar as in-service candidates are concerned.
See,
It nowhere says that 233(2) is not available to in-service candidates.
Well, it's where Rameshwar Dayal and Chandra Mohan say that 233
So therefore,
1.
it is better that you take us to Rameshwar Dayal and Chandra Mohan.
Very well. Very well.
So that you can buttress your submissions.
Very well.
On the basis of findings,
Very well.
we will have to
Yes.
have to consider whether their interpretation of Rameshwar Dayal and Chandra Mohan is correct.
Very
and
well.
your interpretation is correct.
Very well. Highly kind.
Or we are required to give some third interpretation to it. We are not bound to accept their entire argument, neither your entire argument.
No, absolutely. Absolutely.
You might find that the third interpretation is a more correct interpretation.
Yes, as long as it's within the 3 constitution bench judgments.
Yes, it is.
Of course.
We can't travel.
Yes.
If we if you disagree with any of the constitutional benches, the only option available is
To go to 7.
to go to 7.
Yes, I agree, Milits. Now, Milits, now let us see Rameshwar Dayal once again.
Yes, please.
And please see, Milits, I'll be very quick because I'm running out of time again, Milits, but I have a lot to cover. So kindly come.
Okay, you don't encroach on your time now.
Yes, yes, yes. So, Milits, at 104. Like so many overs, Milits, and so many runs to score.
You are competent.
At 104 Milits in 5.1, in 5.1, volume 5.1.
While let's to start from 103.
Last sentence.
Yes, Milits.
Sani, PR Sani, the last sentence.
Yes, Milits.
Or you can read from para 5.
Para 5. Respondent Sani was called to the bar on 17 November 30, was enrolled as an advocate so-and-so. After partition, he shifted to Delhi and worked for some time as legal advisor to so-and-so. He practiced for some time at Delhi, then accepted service under so-and-so, so-and-so. On March 30, 1949, he became chairman Improvement Trust. May 6, 49, he got his license to practice as an advocate suspended. On April 6, 57, he was appointed district session judge. It would thus appear.
Just one question.
Yes.
I think Bar Council, somebody is representing Bar Council also. Mr. Gupta was there for Bar Council of No. So on a judicial officer being appointed as a civil judge, junior division or whatever it is, whether he stands suspended or cancelled.
Perhaps so.
Therefore,
But when you still check it, yes. Yes.
to my understanding, it is suspended.
Yes.
And it revised the moment he demitted his office.
Yes. Yes. It should be.
Unfortunately, that's not available for us.
I'm sorry, Milits.
Unfortunately, that advantage is not available for all 5 of us.
We don't know whether it's unfortunate or fortunate.
Even if you retire as High Court judge, your son revives.
Yes, of course.
We get so many applications for retired judges for designations.
Absolutely. Absolutely.
2 of them appearing on either side in this bill.
So,
I do the Patwalia.
why do you forget Mr. Giri? Mr. Giri? No, Mr. Marlapalle is on a different pedestal. Mr. Marlapalle completed his entire tenure and then joined the bar. All 3 of them for different reasons. Mr. Giri, Mr. Naidu, and Mr. Patwalia.
But they're all on that side with us.
Mr. Patwalia jumped the right side at the right moment. But the Sarath, on being appointed, the Sarath stands only suspended, not cancelled. But it can be revived. On demission of office, on application, it revives.
As I was saying, Millit, they're all on that side.
Because they have experience of the working of the High Court.
Yes. Now, Millit.
Mr. Marlapalle has a longest experience because he was associated with that so many administrative committees.
Yes. Kindly come to 106.
And Mr. Marlapalle and me both repent for a wrong decision we had taken in 2008.
It's not doubly blessed, Lord, they have the agencies twice. Lord say, Mr. Giri, Mr. Patwalia and Mr. Naidu have been doubly blessed.
Yes. Why do you say doubly?
It should be triply. Or...
multiplicity.
Yes, sir.
Yes.
Now, let's kindly come to to page 106. 106 minutes.
So you wanted to read 104.
Well, that's all right. I'm short on time, so I'll just quickly make the point, then go to Chandramohan. Now, 880, page 106, clause 6.1 is noticed. Thereafter, at 107, section 8 is noticed.
Section 18 of the Bar Council Act.
I'm sorry,
Section
yes.
8 of the Bar Council Act.
Yes, yes. And I'll show how it stands today. Then now come to page 110. Till about 10 lines from the bottom is regarding 124, 217. I made the point, I won't repeat that. Kindly come to the part starting Article 233. Till there, Milad, it's on 124, 217. That point is made, Milad. I'll move further. 233 is a self-contained provision regarding appointment of district judges. I just pause, Milad. My understanding is, as expounded, this has been further clarified in Balmukund, that it's complete. You don't need to.
Therefore, but not 233 2. 233 1 read with 2 is a complete code.
Yes, Milad. But Milad, there, whether we should then read into it, Milad, that it means also in service and then provide a qualification. So that's from that standpoint, I say, Milad, it's self-contained. And if we have to put so much into it, then obviously it's not self-contained, Milad.
Then
Then
we
further,
have to decide whether we have
of course,
whether we have to put something or which is already there.
yes, Milad. Then, Milad, as to a person who is already in service of the union or the state, no special qualifications are laid down in clause so and so. The governor can appoint such a person as a district judge in consultation with the relevant high court. As to a person not in service, qualification laid down in clause 2, and all that is required, he should be an advocate or pleader of 7 years standing. The clause does not say how that standing must be reckoned, and if an advocate of Punjab High Court is entitled to count the period of his practice in Lahore High Court for determining standing at the bar, we see nothing in 233 which may lead to the exclusion of the period for determining eligibility for appointment. Then, Milids, on the same page, at the foot of the page, here they are dealing with the other 3 gentlemen, Milids, who were continuing to be advocates, and they say they are clearly eligible under 233.
One of them, the most eminent judges
Of course, Milids, of course, absolutely, Milids. Then, Milids, the page over, at 888-112, the entire discussion on the rule and the clause starts, section 8 and Milids clause 2. That whole discussion goes down. And at the foot of page 112, Milids.
They did not cease to be advocates.
Yes, ma'am. So they did not cease to be advocates at any time or stage after August 1547. And they continue to be advocates of the Punjab High Court till they were appointed as district judges. They also had the necessary standing of 7 years to be eligible. These conclusions really dispose of the appeal. We may state, however, there is that an alternative argument based on so and so, about 5 lines down. As we are resting our decision on conclusions drawn from the High Court Order 47 and Section 8 of Bar Council Act, we consider it unnecessary to examine so. So their decision here, Milids, is based on their being advocates and not in service. And that is what Chandra Mohan interprets Rameshwar Dayal to be. Chandra Mohan says in so many words that this decision is premised on their being advocates, not in service. Therefore, what has fallen from your lordship?
They did not cease to be advocates. Though they were in service, they did not cease to be advocates.
So, Milids,
So therefore, again, the question would be whether a judicial officer, after being appointed as a judicial officer, ceases to be an advocate or is suspended.
so Milids, at that time,
And here also, here in Swani specifically had applied for suspension of his sanad.
Milids, here they have,
He had applied for, if you read page 103,
yes, Milids.
he had applied for suspension of his sanad.
Milids, in my understanding, here they have gone on the premise that under Section 8, you continue to be an advocate. And they say in so many words that our decision is based on this. It is not based on their being in service. It is based on.
So therefore, we will also have to consider what is the provision in the Bar Council of
Now,
Advocates Act.
Now, Milids, at this time, this was Milids Section 8, which did not prohibit, did not require. This was the Section 8 that I placed yesterday. I will show how 49 today stands, which is Milids, the relevant provision, which has been seen. Now, kindly come to Chandra Mohan, Milids, which your lordship will find, Milids, in the same volume at page 180. In the same volume, Milids, page 180. Kindly first come, Milids, to page 185. Take, I'll add 103, no problem. 185. Which are, Milids, the arguments.
Yes.
Argument of learned counsel for the appellant may be placed conveniently under the following 5 heads. While under 233(1) of the Constitution, governor has to make appointments of persons to be and posting of so and so, so and so. I'll skip that. 2. On a fair reading of the provisions of the rules, it is manifest that the High Court is a transmitting authority while the selection committee is made the real consultative body, that is to say the governor has to make the appointment not in consultation with the High Court as it should be under the Constitution, but in consultation with the committee constituted under Rule 3. Governor has no power to appoint district judges, that's 3 minutes, to appoint district judges from judicial officers as they were not members of judicial service. 4, the exclusion of members of judicial service in matter of direct recruitment offends 1416 of the Constitution. Now, they never went into 4 minutes, but they don't go into it for reasons they've stated there, which I'll show presently. But that question is...
Judicial service, which judicial service?
No, that's right. Of course, Melissa, that's right. There's no doubt on that. Judicial service means judicial service, not judicial.
The judicial service, they were considering also where the executives were the part of the judicial service.
Yes, I agree. No, Melissa, judicial officers and separate from judicial service, and they've explained that here. So they are under judicial service as understood by Chandra Mohan and not judicial officers as understood, Melissa, in pre-independence. This is what Chandra Mohan says. That's one part. Now, please come, Melissa, kindly turn the page over to Melissa, page 187. But I'll remember this. Page 187. Very briefly, Melissa, the rules they were considering, Rule 14.2 concerning direct recruitment, application by barristers, advocates, vakils, so-and-so should be submitted by district judge concerned and must be accompanied by certificate age of so-and-so. Applications of judicial officers should be submitted in accordance with rules so-and-so. The district judge or other officer through whom the application is submitted shall send to the court along with the application his own estimate, etc.
Therefore, these rules permitted both the judicial officers as well as the lawyers to apply for the direct recruitment.
No, kindly read. Applications from judicial officers should be submitted in accordance with rules referred to so-and-so. District judge or other officer through whom the application is submitted shall send to the court along with the application his own estimate so-and-so. Then interview. Yes.
Rule 14 refers to direct recruitment.
Yes, Manoj. Yes, Manoj.
So therefore-
Applications from judicial officers should be submitted in
So
accordance.
that rule only provides that if it is a barrister, it has to wait through the district judge, and if it is a judicial officer, then it has to be made in accordance
Yes.
with Rule 2B of. So that stream is available to both.
Yeah. Now see further ahead, Manoj. I know. That's right. Then 15 minutes. Selection committee shall scrutinize applications received by the court, require such candidates as seem best qualified for appointment, etc. So the selection committee, so the selection committee was doing the selection work, Melissa. And your lordships then consider this on the next page at Melissa, page 188. And they notice, Melissa, they notice these rules, the powers of the selection committee, and kindly come to 189.
Yes.
Kindly see the new paragraph, Melissa. I rely upon this. The position in the case of district judges recruited directly from the bar is worse. Under Article 233(2) of the Constitution, the governor can only appoint advocates recommended by the High Court to the said service. But under the rules, the High Court can either endorse the recommendation of the committee or create a deadlock. The relevant rules therefore clearly contravene constitutional mandate of 233(1) and 2 of the Constitution and are therefore illegal.
So therefore,
It's
they
against
take a notice that
233(1).
the district judges, the members from the service could also be appointed directly as district judges.
Melissa, they don't say that, Melissa.
So the position in the case of district judges recruited from bar is the worst.
Yes. Why? Because the selection committee is doing everything. And they say 233(2) of the Constitution, governor can only appoint advocates recommended by the High Court to the said service.
Yes, the Honorable Chief said, because in that committee, they disapproved the recommendation of the committee. They said the committee cannot take the role.
Whether we put, let us see, Melissa, let us
Then
see.
read the next line.
Yes,
The
yes.
relevant rules therefore clearly.
But under the rules, the High Court can either endorse recommend.
Article 233(1) and 2.
Melissa,
That's why we are saying one also applies to the appointment.
Melissa, with great respect, Melissa.
Yes.
When they say, but under Article 233(2) of the Constitution, governor can only appoint advocates recommended by the High Court. This is the understanding.
Please read the next line, but
Yes,
why,
next
why
line,
you
Malad.
are saying so?
But under the rules, the High Court can either
What
endorse
next line?
recommendation or,
Ah.
yes, Malad.
Either endorse the recommendation of the committee or create a deadline. That's not permissible, they say.
Yes.
That is not permissible. What is permissible recommendation? So far as the advocate is concerned, he doesn't say that the judicial officer excluded. Then you come to next line.
Well,
Therefore, clearly contrary to the mandate of 233, 1 and 2. Therefore, 1 and 2 have to be read together so far as the judiciary, the governor vis-a-vis the recommendation of the High Court is concerned.
Malad,
See, 233 by its nature speaks about only appointments.
yes, sir.
Now, unfortunately, we keep compartmentalizing it as 1 and 2 and this and this. How is it permissible for us while interpreting the constitution? It says only.
They were considering the interpretation of the rules where the governor was given a supremacy.
Yes.
I agree with
Oh, all
the
the High
Select
Court.
Committee. Malad, yes, but they also say under 233, only advocates recommended. It doesn't say advocates and judicial officers or those in judicial service.
On the contrary, it says that the position in the case of district judges recruited directly from the bar is worse.
Yes.
So it takes into situation and contemplation, takes into consideration and contemplation where the district judges can also be directly appointed.
Yes, Malad. So, yes, Malad, that's right. In the case
their
of district
condition is
judges, recruited directly from the bar is worse. That's right. Because district judges are contemplated to be recruited from the bar and then goes on to say those only advocates recommended by the High Court. That's one, Malad. That's what I rely upon, one part. Then, Malad, kindly move further. And kindly, Malad, 2 pages down, kindly come to 192. After they notice 233, 234, 235, 237. Kindly come, Malad, to 192 top. The gist now, their first, Malad, this is their understanding of these provisions 233 onwards. The gist of the said provisions may be stated thus. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state. There are 2 sources of recruitment, namely service of the union or of the state, 2 members of the bar. Said judges, please mark, Malad. So the service judges, the said judges from the first source are appointed in consultation with the High Court, and those from the second source are appointed on recommendation of the High Court. Now, Malad, 233(1) uses the word consultation, 233(2) uses the word recommendation. If what my lord is saying is correct, then Malad, this paragraph has no meaning in my most respectful submission. Here they are very clearly saying,
Recommendation is for the purpose of eligibility,
let's kindly see.
suitability,
Well, let's-
whatever you can say.
I'm sorry, let's
They
read
are
this again.
in the process of-
Well, let's kindly see this again.
See-
There are 2 sources of recruitment. One, service of the union or of the state.
See, Chandra Mohan itself, there's a case where application has been called for 10 posts for recruitment to the district judge. It does not deal with promotion. That is what we have been trying to tell you. It on its own, there is absolutely no need for any argument in this case. Chandra Mohan, what it does was, it doesn't deal with promotion. Promotion is a separate channel. But it takes care of the 10 vacancies in the direct recruit. In that process, they are called for application. In para 1 itself, we make it very clear. Now, the committee recommended, they said no, committee cannot recommend. There are only 2 issues. The committee recommendation, how to go with it. What is the jurisdiction of the governor, what exercise he can do. Then ultimately, how do you define your judicial service? They say the government servant cannot be permitted. Therefore, they struck the rule down. But there is no issue with respect to the consideration of a judicial officer under the direct recruit. That is a problem there.
Well, but whether a problem or no, my understanding of what is said has to be seen. Now, please see again, Millet, and then I'll explain the next part which the other side relies upon. They are very clearly saying 2 sources. Number 1, service of the union or of the state.
Yes.
Why does, well, let's kindly see, why does 233(2) say not already in the service of the union or the state? They say that is the first source. Those who are in the service. And second source is those who are not in the service of the union or state, that is the bar. And then they say the said judges from the first source consultation with the High Court and those from the second source on the recommendation, clearly demarcating 1 and 2 respectively. Now, that's a submission for you.
That's why Honorable Chief has also brought you a notice of Rule 14. Rule 14, it does not, by itself, that part is not set aside. No issue at all. Rule 14 calls for application from both channels.
The rules are struck down, Malad. The rules are struck down.
Courts are struck on a different ground, on the interpretation that government servant cannot come in, not on the ground that the judicial officer is not entitled.
With greatest respect, if the court is saying something so clearly in so many words, in my understanding, this is what it is. Malad.
Yes.
Now further. Then Malad, the rest, now come to the next paragraph. So they say, so far there is no dispute. Now they come, Malad, to the other question, which is now whether judicial officers and judicial service concerning that, Malad, but the real conflict rests on the question whether the governor can appoint as district judges persons from service other than judicial service. This discussion now considers here 233's interpretation is complete there, where they say there is no dispute. On this aspect, the discussion starts. And then they say, Malad, what the other side relies upon, that the acceptance of this position would take us back to pre-independence, etc. In princely states, one of so and so. This would also come across well-knit scheme of the constitution, principle underlying, namely judiciary shall be independent service. Doubtless 231 stood alone. It may be argued governors may appoint any person as a district judge, whether legally qualified or not, if he belongs to any service under the state. But 233 is nothing more than a declaration of the general power of the governor in the matter of appointment of district judges. It does not lay down qualifications of candidates to be appointed or denote the source from which the recruitment may be made. Source of recruitment are indicated in two. Under clause 2, two sources are given, namely persons in service of union state and number 2, advocate or pleader. How do they say that? Because 2 says not already in the service of the union or the state. So they are saying that is the category left out. That is the one which comes under 1. That is what clearly, this is the understanding, Malad, in my most respectful submission.
Yes, we consider that.
Yes. Then the advocates or pleaders, the second part. Now let's turn the page over, which is, Malad, another important part I want to rely upon. Consider that, Malad, that's the submission, Malad, whatever it is worth. Now, Malad, they, in the lower part of this lower page, Malad, at page 193, they consider Rameshwar Dayal and see the quoted part and then see what they say there, Malad. This is important, Malad, because here they are now directly considering Rameshwar Dayal. 233 is a self-contained code provision regarding appointment of district judges. As to a person who's already in the service of the union or the state, no special qualifications are laid down under clause 1. The governor can appoint such a person as district judge in consultation with the High Court, relevant High Court. As to a person not already in the service, a qualification is laid down in clause 2 and all that is required, he should be an advocate. Now let's please see the next part is important. This is a discussion now. This passage is nothing more than a summary of the relevant provisions. The question whether the service is in Article 233(2) is any service of the union or the state did not arise for consideration in the case, nor did the court express any opinion thereon. We therefore construe the expression service in clause 2 of Article 233 as judicial service. Now, Malad, but it is said that this construction ignores 237 of the Constitution. We do not see how 237 helps the construction of 233(2). Article 237 enables the governor to implement the separation of judiciary from executive. Under this article, governor may notify 233(4)(5)(6) of the Constitution will apply to the magistrate subject to certain modification or exception. For instance, if the governor so notifies the said magistrates will become members of judicial service, they will have to be appointed in the manner prescribed in Article 234. They will be under the control of the High Court under so and so, and they can be appointed as district judges by the governor under 233(1). So, Malad, they say that there, Malad, and to state it differently, they will then be integrated in the judicial service, which is one of the sources of recruitment to the post of district judges. Indeed, Article so and so emphasizes. So, Malad, when they say passage is nothing more than so and so, the question whether service in
deals with integration. So unless they are brought in the judicial service,
yes,
the executive magistrate also,
yes,
and unless there is an integration,
yes,
they are not entitled to be
yes,
appointed.
now the part I want to emphasize is at the bottom of 193. After Rameshwar Dayal, they say this passage is nothing more than a summary of the provision. The question whether service in 233(2) is any service of the union or state did not arise for consideration in that case, nor did the court express any.
Rameshwar Dayal, the question as to whether the service in union or the state is exclusively a judicial service or not. That did not fall for consideration in Rameshwar Dayal, and we are deciding it for the first time in this case that it will mean service in the union or the state will mean only judicial service.
I bow to that, Malad. But it also means, Malad, in my most respectful submission, that Chandra Mohan understands Rameshwar Dayal to be a case which has come of direct recruitment from the bar. That's why they say service is not being considered there. Because I want your lordship to just be aware of my submission, Millet. Then of course, that's after that, Millet, your lordship will consider that. Because Rameshwar Dayal says that we are now considering them from the bar and because of section 8 and clause 2, etc. And this is what is doubly enforced is my submission. Now, Millet, this is insofar as Chandra Mohan is concerned. I've said that. Yeah, I've said that. Now, let's now kindly come back to my note. Page 50 minutes. My lord has my note minutes. My submission at page 50. Page 50 minutes of my submissions. Volume 2 minutes, what your lordship had. Well, it's at page 50 minutes after the new judgment, Panduranga Rao. They quote minutes from Chandra Mohan that there are two sources of recruitment. My lords have that minutes. Two sources of recruitment, namely service of the union, members of the bar, said judges from the first source are appointed in consultation with the High Court. Those from the second source are appointed on the recommendation of the High Court. So, this is what Panduranga says. Panduranga has been later followed in the subsequent constitution bench in Malbukal. Then comes Satya Narayan. My learned friend read that to your lordships extensively yesterday. I may point out that Satya Narayan considered Rameshwar Dayal vis-a-vis Harbans Singh and Sahni. That aspect is considered in Satya Narayan.
Which aspect?
Of Sahni and Harbans. That aspect, it had fallen from my Lord the Chief Justice, whether Sahni Harbans has been noticed. So without prejudice to my submission that Rameshwar Dayal is premised on their being advocates as endorsed in Chandra Mohan, it has subsequently been considered in Satya Narayan, is my submission. So Satya Narayan considers it specifically, on internal page 117. My learned friend, Mr. Chandra Uday, has shown that yesterday. I won't repeat that. Then, this is what Satya Narayan says. I've quoted the relevant extracts, so it becomes a little more convenient for your lordship. And then, Sushma Suri is considered, is quoted there at page 50 at the bottom. Then, kindly come to page 51, and your lordship will find the judgment in Deepak Agarwal, Justice Loda's judgment, where I will like your lordship in volume 5.2 to kindly see page 668. 5.2, 668. At 688. Your lordship saw rule 8 as seen at the time of Rameshwar Dayal. And here, in this judgment, at 688, at the bottom, rule 49, just above the quoted part, rule 49 in its present form, consequent on amendment, reads as under. An advocate shall not be a full-time, page 688. My Lord the Chief Justice has that. At the bottom of 688, paragraph 18, the quoted part, rule 49 in its present form, consequent on amendment, reads as under. An advocate shall not be a full-time salaried employee of any person, government, firm, corporation, or concern. So, this is the shift from rule 8 in my understanding, and after the amendment, this is what it was. And after noticing all of that, if your lordship will come to page...
An advocate shall not be a full-time salaried employee of any person, government,
firm, corporation, or concern, so long as he continues to practice, and shall, on taking up any employment, intimate that fact to the Bar Council on whose roll his name appears, and shall thereupon cease to practice as an advocate, so long as he continues in such employment. But Rule 8 has been understood to mean at that time that you continue to be an advocate in Rameshwar Dayal. So this is a change, Manoj, which has happened. Which is why Rameshwar Dayal premises his on his being an advocate.
They read
And
further, nothing in this rule.
the High Court, my lord is reading, Manoj, that, I'm sorry.
Nothing in this rule.
The High Court has held in our view rightly that the consent of...
After 49,
Oh, I'm sorry, very well. Nothing in this rule shall, I was reading at the bottom, I'm sorry. Nothing in this is prior to 2001. Nothing in this rule shall apply to law officer of the central government or of a state or any public corporation or body constituted by statute who's entitled to be enrolled under rules so-and-so of state bar council so-and-so, despite his being a full-time salaried employee. Law officer for the purpose of this rule means a person who is so designated by the terms of his appointment and who by the set terms is required to act and or plead in the courts on behalf of his employer. Then, Malitz, there's a resolution of 22/6/2001, and after that, Rule 49 in the present form is quoted. An advocate shall not be a full-time salaried employee of any person, government firm, corporation or concern so long as he continues to practice, and shall, on taking up any employment, intimate the fact to the Bar Council on whose roll his name appears, and shall thereupon cease to practice as an advocate so long as he continues in such employment. So this is the shift from Rule 8 at that time to now. Now, let's kindly come in this very judgment to page 698. ऐसे दिखा चुके हैं. अच्छा, ये नहीं दिखाया. Para 42. Article 233 of the Constitution makes provision for appointment qualification of district judges. I'm sorry, page 698. Page 698.
yes.
Just below placetum F, we have to find out what is the meaning of the expression "the service" under 233(2) of the Constitution. Expression "the service" occurring in clause 2 of so-and-so came up for consideration before a constitution bench of this court in Chandramohan. Then the Mallets refer to Chandramohan in detail. Your Lordship may skip all that. And after recording their conclusion, que that Mallets, they move on and kindly come to page 738. Where is it? What's the difference in the pages now? Well, if your Lordship will now take page 738, well, it's para 77.
Yes.
We do not think that there is any doubt about the meaning of the expression advocate or pleader in Article 233(2). This should bear the meaning that it held in law preceding the Constitution as the expression was generally understood. Expression advocate or pleader refers to so-and-so, so-and-so. There is no indication in the context to the contrary. It refers to members of the bar practicing law. In other words, expression advocate or pleader so-and-so has been used for members of the bar who conduct cases or any other words, acts and or pleads in court on behalf of his client. Sushma Suri, 3-judge bench of this court construed expression members of the bar so-and-so. Public prosecutor roles of so-and-so, so-and-so are entitled to practice was held to be covered by the expression advocate. Then, Mallets, your Lordship may come to 743. And 744, Mallets, where they go on the point of present continuous. Just on that aspect, paragraph, Mallets, 85 and 88. Just make a note of that, Mallets, where they go on has been and present continuous.
Para 85.
Yes, Mallets. 85, the last part. The factum of employment is not placetum between placetum B and C at page 743. The factum of employment is not material, but the key aspect is whether such employment is consistent with the practice, with his practicing as an advocate, or in other words, whether pursuant to such employment, he continues to act and or plead in the courts. If the answer is yes, then despite employment, he continues to be an advocate. On the other hand, if the answer is negative, he ceases to be an advocate. Then Millards, your lordship may now, Millards, now,
2030, they hold that public prosecutors,
yes,
in spite of an amendment in 2001 to the rule, wherein the second paragraph and third paragraph have been deleted,
yes, Millards, yes, Millards,
they still hold the public prosecutors to be advocates.
yes, Millards, yes, Millards, yes, Millards, because you are in practice. And rightly so. Now, Millards, come back to my note, Millards. I'll move fast, so I want to show Balmukund in detail, Millards.
Yes.
Page 51.
Balmukund.
At first 51, Millards, I'll just show some extracts from other judgments, then I'll come to Balmukund straight away. Millards, at the foot of 51 is another 5-judge bench judgment, which very briefly refers to 233. At the foot of Millards, page 51 of my note.
Rita Baby versus Dixitulu.
Yes, Millards. This is also another constitution bench. Article 233 gives the High Court an effective voice in the appointment of district judges. Clause 1 of the article peremptorily requires appointment of persons to be and the posting and promotion. District judges shall be made by the governor in consultation with the High Court. Clause 2 of the article provides for direct appointment of district judges from advocates or pleaders of not less than 7 years standing who are not in this already in the service of the state or the union. So, Millards, this is how they understand 233(2). In the matter of such direct appointment, also the governor can act only on the recommendation of the High Court. Consultation with the High Court under 233 is not an empty formality. Appointment made in direct or indirect disobedience so-and-so should be invalid. See Chandramohan so-and-so. Service, which under clause 1 of the article is the first source of recruitment of district judges by promotion, means judicial service as defined in so-and-so. Word posting as used in 233 in the context of appointment and promotion means the first assignment of an appointee or promotee to a position in the cadre of district judges. Then, Millards, comes the All India judges.
This judgment is,
5 judges.
no, but it is part of a compilation.
No, Millards, it is not. It is not, Millards.
We have made it a part of compilation.
Yes, Millards.
And you will get it.
Yes. Relevant, Millards. That's why I've quoted the relevant.
Relevant. We can't find the relevance unless we notice the facts.
Oh, Millards. That's
There's an abstract observation here and there without application thereof to the facts of the case.
Millards, Justice Sarkaria here was considering Article 371D. It was concerning that, but yes, these observations are made, Millards.
So we have to,
Yes, Millards. Yes. Yes.
what are the facts for consideration?
Yes.
Whether this observation will be an arbiter or
If, I'll just come back to this, Millards. I want to show Balmukund in detail. Now, Millards, the next is All India judges, and that is important. Let's get that. Now, Millards, in All India judges, your lordships have very clearly laid down 25% from the bar. My submission is, and Millards, at page 52 at the foot, is that famous extract, Millards, first para 27 in the lower half. In order to achieve this, while the ratio of 75% promotion, 25% direct recruitment, so and so is maintained. And then the lower part, Millards, para 28C, 25% shall be filled by direct recruitment from amongst eligible advocates on the basis of written test viva. Understanding again being that 233(2) from the bar exclusively for advocates. It proceeds on that premise.
on the basis of Satyanarayan and Shivdi Commission.
Well, this is the understanding. It was not that this was doubted. It was not that 233 is considered and a different view was felt. But the very basis, Millards, of that is that, yes, this is meant for them and they proceed on that. Now, that's my submission, Quay Millards, the first All India judges, Justice Kirpal's judgment. Then page 53. I have, Millards, quoted from Panduranga and Lakshmi Kutty. Both these, I've quoted the relevant extract, Millards. And both of these have been approved in Balmukund. So I'll just read this para here, Millards. Para 8, a candidate for direct recruitment from the bar does not become eligible for appointment without recommendation of the High Court. He becomes eligible only on such recommendation under clause 2 of 233. High Court in the judgment under appeal felt some difficulty in appreciating the meaning of the word recommended, but the literal meaning given in concise Oxford Dictionary is quite simple and apposite. It means suggest as fit for employment. In case of appointment from the bar, it is not open to the government to choose a candidate for appointment until and unless he is recommended by the High Court. Then Malad Lakshmi Kuti. Heart of the matter is that consultation between the state government and the High Court in the matter of appointment of district judges under 233(1) of the Constitution must be real, full, and effective. To make the consultation effective, there has to be an interchange of views between High Court and the state government, so that departure from the advice of the High Court could be explained to the High Court by the state government. If the state government were to simply give lip service to the principle of consultation, depart from the advice in making judicial appointment without referring back to the High Court, difficulties which prevent the government from accepting its advice, consultation would not be effective. And any appointment of a person as a district judge, please mark Malits, by direct recruitment from the bar or by promotion from judicial service under 233(1) would be invalid. So Malits, again, in my understanding, the three honorable judges, Malits, the two honorable judges in Lakshmi Kuti understood direct recruitment from the bar or by promotion from judicial service under 233(1). They don't say, Malits, direct recruitment from the bar and from in service or from promotion from judicial service. They don't say that.
We'll have to consider whether
Yes,
that,
yes.
that is correct or not.
Yes, Malad. Malad, this is approved in Balmukund. I'll show that. I'll come to that. Then, Malad, the page over. Continuing with the same judgment, Malad. Para 24. Appointment of persons to be and the posting and promotion of district judges.
Where reading?
Page 54, para 24, Malad, about 5 lines from the top. Balmukund.
Yes.
Appointment of persons to be. This is Lakshmi Kutti's quote only, Malad, going on. Appointment of persons to be and the posting and promotion of district judges in the state shall be made by the governor of the state under 233(1) in consultation with the High Court, exercising jurisdiction in relation to such state. Sub-article 2 thereof provides that a person not already in service of the state of the union of the state shall only be eligible to be appointed as a district judge if he has been for not less than 7 years an advocate or pleader recommended by the High Court for appointment. It is therefore obvious that eligibility of appointment of persons to be district judges by direct recruitment from amongst members of the bar depends entirely on recommendation of the High Court. State government has no part. Chandra Mohan have established in principle as a rule of law the consultation between governors so-and-so in matters of appointment so-and-so under so-and-so must not be an empty formality. That part, Malad, just to re-emphasize that part from the bar. Now, Malad, kindly take Balmukund, which your lordship will find, Malad, in your volume, in volume 5.7, page 4445. कैसे होगा just give me the pages, huh?
PDF 337.
And we don't have that. Just call the fair. Just one. Let's say if your lordship will come to 664. To internal page, Malad 664. 664, 664. If my lords permit, may I read the internal page, Malad?
Internal page.
664, Malad. May I refer to that if it's not inconvenient for your lordships? May I refer to the internal page, Malad? It's
Yes.
internal page. It's running page 4469. Between placetum E and F, the issue, Malad. That's where the judgment begins, Malad. In both these appeals, my lords have that, Malad. I'm sorry.
Yes.
Paragraph.
Malad, the second para itself, Mr. Courtmaster, just hand that over.
Running page 4469.
The beginning, 664. Page
4469 is the running.
4469. Okay.
Map between placetum E and F, Milits, in both these appeals, my lords have that, Milits. Internal page 664, paragraph 2, between placetum E and F.
Yes, in both these appeals.
In both these appeals, a common question of law arises for consideration, namely, whether the legislature of the appellant state of Bihar was competent to enact the Bihar Reservation so and so Act 1991, insofar as Section 4 thereof sought to impose reservation for direct recruitment to the posts in the judiciary of the state subordinate to the High Court of Patna, being the posts of district judges as well as the posts in lower judiciary at grassroots level. So and so civil appeal. So this is the issue. Now, the next page, just at the end of paragraph 2, just above placetum D. Thereafter, a 3-judge bench of this court, by its orders 6/11/97, felt that the matter raised.
Where are you reading?
Page, paragraph 2, the last 4 lines of para 2.
Thereafter, 3 judge.
Yes, ma'am. Thereafter, 3-judge bench of this court, by its order of 6/11/97, felt that the matter raised questions regarding interpretation of provision of Article 233, 234, 309 of the Constitution, and hence it would be appropriate that they are heard by a constitution bench. So, 233, 4, etc. were up for consideration. Then, they refer again to certain facts. Your Lordship may skip all that. I have in my note, mentioned some of the important paras, etc. But now, come straight away to running page 4482. Page 4482, where the consideration of Article 233 starts. This is Justice Majumdar's judgment, which is the majority view. Well, it's of the 5 honorable judges, Justice Majumdar's is the main judgment, which was concurred with by His Lordship Justice Patnaik and His Lordship Justice Banerjee, supplementing with their own reasons. So this is the majority judge. And at the foot of page 4482, after quoting in para 26, articles 233 and 234, then I'm reading from there. Placetum G. So, to just clean that up. Step me, sorry. Article 233 dealing with appointment of judges. My lords have that, My lord, the Chief Justice has that. Dealing with appointment of district judges on its own words, on its own express terminology, projects a complete scheme regarding the appointment of persons to the district judiciary as district judges. In the present appeal, we are concerned with direct recruitment to the cadre of district judges, and hence sub-article 2 of Article 233 becomes irrelevant. So, 233(2), direct recruitment, hence this is what is relevant. Apart from laying down eligibility criteria for candidates to be appointed from the bar as direct district judges, said provision is further hedged by the condition that only those recommended by the High Court for such appointment could be appointed by the governor of the state. So, qualification under 233(2), appointment by the governor and recommendation of the High Court. Similarly, for recruitment of judicial officers other than district judges to the judicial service at lower level, a complete scheme is provided by 234. Your Lordship can skip that. Then, kindly come down a few pages and come, 682, to internal page 682, which is 4487. Between placetum C and D. At internal page 682, running page 4487, between placetum C and D. But so far as the High Court is concerned, my lords have that, is concerned, it's in the middle of para 29, between placetum C and D at page 4487. 2 lines above placetum D. But so far as the High Court is concerned, my lord, the Chief Justice has that. I'm sorry. Well, my lord has internal page 682.
Above placetum B.
D, Malaj, just above, 2 lines above placitum D.
But so
So
far as
far as the High Court is concerned, I'm so grateful. Relevant by the thrust of 233 itself, as it is the High Court which has to control candidates who ultimately one gets elected, having to act as judges at the lowest level of judiciary while posting, promotion, grant of leave, and other judicial so-and-so vests only in the High Court as per 235. So-and-so, then Malaj, 2 sentences down. So far as direct recruitment of the post of district judges is concerned, 233 sub-article 2 leaves no room for doubt that unless the candidate is recommended by the High Court, the governor cannot appoint him as a district judge. Now, let's skip that paragraph and come to para 30, which is important at the bottom of the page. It has also to be kept in mind that neither 233 nor 234 contains any provision of being subject to any enactment by the appropriate legislature, as we find in Article so-and-so, so-and-so. These latter articles contain provisions regarding the rulemaking power of the authorities concerned, subject to the provision of law made by Parliament or the legislature. Such a provision is conspicuously absent in Article 233-34 of the Constitution. Therefore, it is not possible to agree with the contention of learned counsel to the appellant state that these articles only deal with the rulemaking power of the governor, but do not touch the legislative power of the competent legislature. This is important, Malaj. It has to be kept in view that once the Constitution provides a complete code for regulating recruitment, appointment to district judiciary and to subordinate judiciary, it gets insulated from the interference of any other outside agency. We have to keep in view the scheme of the Constitution, its basic framework, and the executive as so-and-so. So, Malaj, again, emphasizing complete code.
it has to be separated from the judiciary.
And Malaj, it's a complete code. 233, 234 provide a complete code. Then, Malaj, your Lordship may skip the next few pages again and kindly come, Malaj, to para 37, which your Lordship will find at Malaj's internal page 689 at 4493. And kindly come to 4494. 4494 minutes. My lords have that minutes? 4494. 4 lines from the top, where they minutes refer to a 3-judge bench of this court in Panduranga Rao. My lords have that minutes?
Yes, the 3-judge bench.
Which I showed earlier minutes, where they again reproduce Panduranga Rao and then say, and thereafter the following pertinent observations were made in para 8. So, Malaj, I understand it, they're affirming that.
They say they consider Panduranga as to whether any person can be appointed as a district judge without the consultation of the High Court.
Yeah.
The issue there was as to whether the governor has the power to make an appointment
Yes.
without the consultation of the High Court.
Malaj, I'll just read.
Without the recommendation of the High Court.
I'll just read. I'll read. Malaj, let's read the first quote, Malaj. There are 2 sources of recruitment, namely 1, service of the union of the state, 2, members of the bar. Now, please note this. Said judges from the first source are appointed in consultation with the High Court. From the second source, appointed on recommendation. Consultation is 1, recommendation is subclause 2, is what is clear, Malaj, in my understanding. And they, Malaj, rely on Chandramohan and say this, and they approve of this. I'm reading the text.
Even then, the first part will not be complete.
Now, Malaj,
This
I'm
is obvious.
placing how it has been understood. Malaj. Then, Malaj, then they say, after the 2 quotes, Malaj, I'll read the next line. It is therefore obvious that the state legislature has no role.
For 10 posts,
Yes.
50 lawyers may apply. High Court may, in his recommendation, may find 40 of them are eligible. Then in that, after going through the process, only 5 will be qualified. Then in that 5 recommendations required. It's a simple way. Before appointment, government will consider the recommendation. Only one is for eligibility, another is for appointment. It's a obvious. So
Now, Malaj,
whatever word they use, it's so obvious.
Now, Malaj, I'm reading after the quote. It is therefore obvious state legislature has no role. Article 233, so and so, grassroots level. Then 2 lines down, Malaj, 234, and can only, and it is only the governor who's entrusted with the set task which he has to
There is
undertake.
no dispute that is the second stream. The question is the stream with regard to the recruitment from the bar excludes judicial officer or not.
So, Malaj, I'm just relying upon that part and can only on the recommendation by the High Court for direct recruitment from the bar. Again, for being appointed I'm trying to emphasize, Milits, they again say for direct recruitment from the bar for appointment under 233(2). That's the part I'm trying to rely upon. Then, Milits, very quickly, Milits, para 41 at page 692, which is 4497. 10 vacancies, Milits, example is given here, and my understanding of it is. Okay, quite 15. Well, it's para 41. We may take an example to highlight this position. Supposing there are 10 vacancies of district judges at a given point of time, which are available to be filled in by direct recruitment, keeping in view the ratio of such direct recruitment permissible under the relevant rules. Once these 10 vacancies of district judges are required to be filled in by direct recruitment on the recommendation of the High Court from the members of the bar, subject to minimum eligibility laid down in 233(2), the High Court obviously has to undertake the exercise of selection governor in such a case once. Again, it's contemplating only from the bar. And
Question is from the bar whether it excludes the persons who have judicial offices.
There is no express finding here.
well, it's again at the bottom, once the High Court undertakes such an exercise and prepares a panel of eligible and suitable direct recruits from the bar after holding appropriate tests. Well, it's otherwise, if they are in service, they can't be from the bar, Malats. If they are in service, they are not from the bar. And when they say bar again and again,
Ratio laid on here, no ratio laid on this issue itself is different and no ratio is laid on the risk.
now Malats, now kindly see Malats para 65, which is internal page 720, which is the concurring view of Justice Patnaik, which your Lordship will find Malats at running page, internal page 720. 4525. Para 80, page 728, 720. About 5 lines from the bottom. Under Article 233, my lords have that minutes. Under 233, the power of appointment, posting, promotion of district judges in any state has been conferred on the governor of the state in consultation with the High Court, exercising jurisdiction in relation to the state. It obviously deals with those officers who are to be promoted to the rank of district judges in the superior judicial service from the post of so-and-so. Sub-Article 2 of 233 of the Constitution makes provision for appointment of persons as district judges direct on the recommendation. This is Malad insofar as the majority view is concerned, which I place for your Lordship's kind consideration. And Malad, lastly, in the minority view, paragraph 80 at page 4533. 4533 is the minority view on the main issue. Para 80 at the foot of internal page 728 and running page 4533. Article 233. My lords have that minutes?
Yes.
Article 233 of the Constitution provides that appointment of district judges shall be made by the governor of the state in consultation with the High Court excising so-and-so. Direct appointment of a person to the post of district judge can be made only if he has been an advocate pleader for 7 years and is recommended by the High Court for appointment. Appointment contemplated under this article is the initial appointment from direct recruit or initial promotion from service. Excise of power appointment of so-and-so. Again, Malis, can only if he has been an advocate pleader for 7 years. My understanding is quite clear. As is Malit, the other part of Justice Patnaik and Malit. And this is the way, Malit, your lordships have understood these passages for 65 years.
What did you say?
I said, Malit, this is the understanding your lordships have had for 65 years of Rameshwar Dayal and Malits of Balmukund and Malits of Anchandra. Malits, my Lord the Chief Justice put to me whether the judgment in the other constitution bench is part of the compilation. It is, Malits. It's in volume 5.6, at page 2240. It was at page 51 of my note, my lords. The judgment of Chief Justice of Andhra Pradesh versus LVA Dixitulu. Don't need to. It's part of the compilation. That's all. That's all. Well, I'll come back to my note, my lords.
Context to the sentence, whether people can go back to.
I'll come back to my note, my lords. I'm now running on borrowed time. Allahabad has been very kind to give me their 10 minutes, my lords. So I'm going to wrap up, my lords, very quickly. At page 54. I'll just run through this, my lords. Page 54, my lords, I've referred to Bal Mukund. In my additional note, my lords, I've given the exact paragraphs which I've just read to your lordship. So, my lords, I have not quoted all of them here to keep it, my lords, brief. Then, my lords, at page 55, I've discussed, my lords, on not already in service. And then, my lords, made my submission on that. At the bottom of page 55, on advocate or pleader, my lords, I've referred to various judgments which deal with that. Sushma Suri in particular, my lords. Then, page 57 is on legislative intent, my lords, on interpretation, etc. My lords. I'll just read from 57 at the top. Para 66 at 57. Primary principle of interpretation is that a constitutional, or this is the 5-judge bench, my lords, or statutory provision should be construed according to the intent of they that made it. Normally, such intent is gathered from the language of the provision. If the language of phraseology employed by the legislation is precise and plain, and thus by itself proclaims the legislative intent in its unequivocal terms, same must be given effect to regardless of the consequences that may follow. Then, well, the next highlighted part, if the language of the meaning of the statute is plain, there is no need for a construction as legislative intention is revealed by the apparent meaning. So on. So then at the foot, resort can be had to legislative intent for the purpose of so on. So, your lordship may skip that. Then,
Well, why do you need to go to the US decisions for this proposition?
I have quoted from what your lordships have said. I've quoted from your lordship judgment, which in turn has approved of what was said in this is a quote from the Constitution bench. Yes. They in turn have quoted Then at page 58, I'm just making the point which your lordships have said. Once you choose a stream, you are bound by it. And if we are right in our understanding that in service have that stream, then they are bound by it, whatever the consequences. So, I have just placed some authorities for that proposition. It's not that they're left high and dry. It's a doctrine of election. They've chosen that stream, and then whatever the consequences. Page 58 are the submissions regarding that. That they have chosen that. That's a condition of service voluntarily sought by them and accepted by them. Then, page 60. Page 60, at the top. Page 60, where I've referred to. My lord has page 60 minutes. If my lord is seeing from that judgment, then page 59, the last quote is the best one. Now, on this, I just want to read this line from
Vaman Rao.
Vaman Rao, another constitution. In the underlying part, the older the decision, the greater its authority, and the more truly was it accepted as stating the correct law. And then para 38 of the same judgment, while dealing with the subject of stare decisis, Shri Sirvai in his book so and so has pointed out how important it is for judges to conform to a certain measure of discipline so that decisions of old standing are not overruled for the reason merely that another view of that matter could also be taken. So, if Rameshwar Dayal, Chandramohan, etc. have been understood in a certain way for 6 decades plus, unless your lordships find that palpably and especially contrary to your lordship's understanding, my submission would be, my lords, your lordship should not relook at it. Then kindly take page 61 also, my lords, at the top, the third line. Justice Sinha said in the same case that if the Supreme Court were to review its own previous decisions simply on the ground that another view was possible, litigant public may be encouraged to think that it is always worthwhile taking a chance with the highest court of the land. Then, my lords, page 62.
We are not proposing to review the decisions of the earlier constitutional bench. We are only considering the correctness of the decisions, referring to those two constitutional bench judgments, whether they correctly construe the law, let down in those two judgments, or they are not correct.
So my submission is, my lords, your lordships have said if a view has held a field for a while. Now, if for 65 years, my lords, the understanding of Rameshwar Dayal, Chandramohan, and for 25 years of Bal Mukund is a certain way, my submission, Koi Vaman Rao, is please continue with that. That's the point I make. Then, my lords, page 62. Page 62, my lords, on this point very quickly. The last quoted part, my lords, from State of Jharkhand, page 62. These precedents have stood the test of time, having full application to the case at hand, could not have been lightly overlooked. Just that part, my lords. Then your lordship may skip all that. Then, my lords, the second issue starts at page 63. And I've already, my lords, on the question whether at the time of application appointment, I've emphasized, my lords, in my note on the use of the expression to be. To be is the word used, my lords, in both. To be recommended. So at the time of application has to be, my lords, seen, because the recommendation will be made of a person eligible at that time. It cannot be, my lords, conceivably that a recommendation is made of a person who will become eligible in future. Cannot be. So, my lords, way that, my lords, I've given a note with some supporting judgments on that issue, my lords. My lords, at 64, my lords, I've emphasized that 64, 65 with certain authorities, my lords. Then at page 66 on has been, my lords, I've quoted from Deepak Agarwal, which I've already shown to your lordship. And similarly at 67, my lords, I've quoted that. Then on the additional issues, my lords, I have page 68, 69, my lords, I have already shown to your lordship. 124, 217. I've made detailed submissions on that, my lords. I won't repeat that. I will just refer, my lords, to Justice Bobde's relatively recent decision at page 71. Purnima. At page 71, my lords. My lord has page 71 minutes. Page 71 at the foot. These are three honorable judges again. But what is important to note is that Article 217 merely prescribes eligibility criteria method of competition. If a person is found to have satisfied eligibility criteria, then he must take his place in one of the queues. There are two separate queues, one from judicial service, another from the bar. One cannot stand in one queue by virtue of his status on the date of consideration of his name for elevation, at the same time keep a towel in the other queue so that he can claim to be within the zone of consideration from either of the two or from both or from a combination of both. Queue to which a person is assigned depends upon his status on the date of consideration. If a person is an advocate on the date of consideration, he can take his place only in the queue meant for bar, member of the bar. Similarly, if he's a person, judicial officer, then so and so. Hopping on and off from one queue to the other is not permissible. Today, if any of the petitioners ceases to be judicial officers, becomes advocates, they may be eligible to be considered against quota intended from the bar. But while continuing as judicial officers, cannot seek to invoke explanation A as it relates to so and so after having held space. Then,
What is the facts in that case?
Well, this is concerning 217, but just on the point hopping on off, Milits. On the point of hopping on and off. They were advocates before Milits joining the service. Then Milits at page 73, 74 Milits, I've again further referred Milits.
There the judicial officers must be claiming
Yes.
from the quota of the
Before.
bar. Having joined as judicial officers,
After joining, and they wanted the period before. So point I'm on is hopping on off minutes.
Just
Yes. Now minutes.
Yes.
Now minutes. Thereafter minutes. I have further minutes made submissions of not less than 7 years at page 75. And then minutes coordinate benches binding my lord the Chief Justice's judgment in Shah Faisal minutes at page 75 at the bottom. And similarly of a constitution bench in Diwan Modern minutes at page 76. Then at minutes on that 145, your lordship will interpret the constitution minutes and where the language is clear, etc. Then page 77 at the bottom minutes, 6 lines from the bottom at page 77. Interpretation cannot create a new constitutional text. Talk of judges amending the constitution through their interpretation of the constitution is just a metaphor. The claim that a constitution limits text limits but does not command is true only for the limited number of cases in which, after exhausting all interpretive tools, we can still extract more than one legal meaning. So just that part. So to summarize in 1-2 sentences, in this additional note, I won't go through it. What I've submitted is also on 233 and 124 with the 3 constitution bench judgments and their relevant pages. I've highlighted in these 2.5 pages, So in one sentence, your lordship is being asked under 233(2), which speaks of those not in service, to read it to mean that those in service are also covered by direct recruitment in 233(2), number one. Then to prescribe qualifications for them, which qualifications are obviously not stated, to prescribe qualifications, number 2. And then, also, if required, add an explanation to that. With greatest respect, we are under 145(3). And I would like to remind my learned friends, we are not in parliament. We are interpreting the constitution the way it stands. This, is really calling for a wholesale amendment to 233, which, in my greatest respectful submission, is not what is to be considered by a I am so deeply obliged, for a very detailed, patient hearing.
Thank you.
May I please, Lord, sir? Lord, I appear in item number 501.28. On behalf of High Court of Gujarat, my lord. And my written submissions are in volume 2, page 228. My lord, as per the
State of Gujarat or High Court of Gujarat?
I'm so sorry, High Court of Gujarat. High Court of Gujarat. And my written submissions in volume 2, page 228. Lord, as per Nodal Council model, I have 55 minutes, my lord. I'll take 45 minutes, and if your lordship permit me, lord, give 5 minutes to my 2 associate counsel to address your lordship, my lord. I have 55 minutes.
You have to conclude by 4 o'clock now.
No, yes, my lord. I'm saying that I will go by schedule, my lord.
You have to adjust your timing.
Yes, my lord. I have 55 minutes. I'll adjust 45 minutes, and lordship would give 5 minutes to issue 2 of us, 2 assisting counsel.
You have to complete by 2:10.
Yes, my lord. I'll do that, my lord. Because my turn come little late, my lord, doesn't matter. I'll try to. May I just formulate my points, my lord, before I invite your lord? My lord, in my respectful submission, the Constitution has provided distinct scheme and mechanism for appointment of judges of the Supreme Court under Article 124, for the judges of the High Court in Article 217, for appointment of district judges in Article 233, and for appointment of judicial officers other than district judges in 234. Their appointee the consultee and the eligibility are separately prescribed. It cannot be intermingled, my lord, between one and another. That's my first submission. I have prepared a chart, my lord, of the 4 provisions, my lord. I'll just place that before lordship. That's one. Secondly, my lord, Articles 124 and Article 233 uses the expression has been, whereas Article 217 uses the word has. Whether has been and has can be, my lord, meaning the same. Because,
What is the submission article?
my lord, may I just give this chart, my lord, which has all the 4 articles, my lord, and which will perhaps clarify before I proceed to the next submission. I've quoted the articles as adopted because there has been some amendment from time to time, not very consequential, because 217 AA was 217 A initially, my lord. 44th amendment made it to AA. So, your lordship kindly see this, my lord. So far as Article 124 is concerned, I'm so sorry. For the Supreme Court, 124(2), just give me my question, provides the appointee and consultee. It says appointment is by the President and consultation with such judges of the Supreme Court and High Court of the states as the President deemed necessary. However, in cases of appointment of judges other than Chief Justice of India shall be consulted. So, my lord, the appointee is President. The consultees are the Supreme Court judges and the High Court judges and Chief Justice of India if there is another. Now, on the right-hand side, lordship would find the eligibility, which is very important for our purposes. 124(3). First is, my lord, a person shall not be qualified for appointment as a judge of the unless a citizen and has been for at least 5 years as a judge or has been for at least 10 years as advocate of 2 or more high courts, and explainer, or 3 is opinion a distinguished jurist. Explanation 2 is important, my lord. It says in computing for the purpose of this clause, the period during which a person has been an advocate, any period during which a person has held a judicial office not inferior to that of a district judge after he has become an advocate shall be included. So, my lord, for clause B, district judge and above, district judge, not any judicial officer, the experience as a district judge is included. My lord, if the argument is accepted that in the direct recruitment quota, which is for advocates, the judicial officers are automatically included, then, my lord, the explanation is not necessary in this. The explanation is being made purposely to include, specifically to include the serving judicial officers or the rank of district judge to be in the quota for advocates, to be in the eligibility. I will not say quota, my lord, to be in the eligibility list of advocates. Now, lordship may kindly come to 217 High Court judges. For the High Court judges, my lord, the appointee is the President and the consultees are the, my lord, Chief Justice of India, the Governor and the Chief Justice of the High Court. I have highlighted, my lord, lordship knows. And, my lord, this has been interpreted by lordship 124 and, my lord, 217. The Chief Justice of India is the Collegium of the Supreme Court or the High Courts, as the case may be. Right-hand side is very important, my lord. 217(2) says, shall not be qualified as has been. It does not say has been. It says has for at least 10 years held a judicial office, has for at least 10 years as an advocate, and explanation A has been added, which means has been a judicial office. So, my lord, the 2 submissions here. So far as, my lord, the High Court is concerned, it does not require a present tense. Has been means a present tense, my lord. He has to be on that date. And 217 to say he has for 10 years judicial office at any point of time.
No, what is the submission for High Court?
Yes.
It is not required that presently it should be.
Yes, my lord, that is what the language says, my lord. Because otherwise, my lord, why there are 2 different languages used for the same purpose? It specifically says Supreme Court has been a judge for 5 years, has been an advocate for 10 years. That means he has to be on the date of appointment. For the High Court, it does not say so, my lord. That's a vital distinction between the 2.
Says so. Subsection say 272B says so.
Yes, my lord. 2B also.
A,
Yes.
here no. 2B has for at least 10 years been an advocate.
Has 10 years been an advocate, but
Has been.
has been an at least 10 years. My lord, what I am submitting is, my lord, he
The clause A only,
Yes, my lord.
has up to a healthy. That's why, because it's for reckoning,
Yes, my lord.
reckoning the period of a judicial officer,
My lord,
that can be
please,
factored in.
please, your lordship.
But for an advocate, otherwise, for an advocate, you should be, because you resign the post and thereafter you come.
Please, your
That is
lordship.
why they say,
Yes,
well, some point of time, if you are a judicial officer,
yes.
that will be taken into account.
Please, your lordship.
There's no need for a currency of the function as judicial officer,
My
as held with the other judgment of the court.
Yes.
You can't travel at the two channels at the same time.
Please, your lordship.
But subsequent B says has for at least,
Has
it has been an
Been an advocate for so and so, but
same thing as
No, my lord, it
140, 121.
has been for, my lord, what I'm saying is, my lord, if your lordship, now more important is, my lord, the explanations. In both the clauses, explanations have been specifically used to include judicial service as an experience for an advocate. Now, if your lordship now come to the next page, my lord,
That is already argued by him.
233, my lord, I'm just trying to explain.
Because the constitution
Yes,
intended that the previous experience has to be taken into consideration.
yes, my lord.
That is specifically provided. It's
In,
not provided in.
is not provided in 230, what is more important?
And therefore, it can't be entered into
No, my lord, what is-
Mr.
No, what is equally more important is in 233, 1 and 2 together does not prescribe any qualifications for the district judges. My lord, it has been,
That's wrong.
my lord,
Because Chandramohan and Rameshwar Dayal clearly hold that for advocates, qualification is provided.
my lord, for advocates, yes, my lord, my alternative submission, what Mr. Gupta has said, 233 clauses 1 and 2 on the reading of it does not provide any qualifications for, it has been left exclusively for the wisdom of the High Court.
That's correct.
Lord, what I'm submitting is, Lord, suppose the High Court, in a given case, in the rules, decides that we will have a particular percentage from direct recruits, from advocates only, and we will have a particular percentage from the district judges only, from the, my lord, judicial service only. Can the judicial officers say that my right is violated?
Not at the
No, my lord,
But
no, my lord, what I'm submitting is, if the,
you're right, see, right from Rameshwar Dayal.
Yes.
It's been clearly said,
yes,
the qualification with, so far as judicial officer is concerned, is
are not provided.
not provided, not prescribed. Now, subsection 2 of 233 provides for lawyers alone.
My lord, what I'm
It's
submitting,
for direct.
yes.
Obviously, it's for direct.
What I'm submitting, I'm so sorry.
Yeah, but
What I'm,
not take away the
What I'm-
judiciary and the High Court and then and the state.
no,
That's
what
it.
I'm submitting is, Lord, High Court,
Related.
in a,
Yeah, that issue.
irrespective of all India judges, suppose the High Court decides, my lord, that both the streams, judicial officers and the advocates are eligible, but we will appoint X percentage from judicial officers and we will appoint X percentage, Y percentage from advocates only. Can the judicial officers, my lord, say my right under the constitution is violated? If your lordships is to hold that,
That's a different issue. See,
no, that is the issue before lordship. High Court rules.
that's what we have been telling him also.
I'm so sorry. Yes.
See, there are the two modes, as all of you are, no, there's no dispute on this.
Yes.
The lawyers will not be considered for the promotion, because promotion is only in-service candidates.
Yes.
So it's a direct recruit. So long a simple question is there any express prohibition? If it is not there,
No,
just because no qualification is prescribed for a judicial officer
Yes.
to participate in that recruit, it will not be supported, would mean it's only meant for the lawyers.
no, my lord, what I'm submitting is, my lord, suppose the High Court decides we will, because the constitution does not put a bar either way. Let's proceed on the alternative, my lord.
That has already been argued by
No.
Yes.
you saying
Yeah, yes.
that when there are rules framed under 309, and the rules provide for a quota for direct judges and for promotion, then this court should not interfere.
No.
But this court, while interpreting the provisions of Article 233, should give due attention to the rules framed by the High Courts or by the state governments in consultation with the High Court under 309. That's what.
No,
was
Lord,
the
yes, I will,
substance of
yes, my lord, I will add a rider that it,
We'll clarify.
um,
For example, in direct recruit, a percentage is carved out, it probably this is a different issue. Because for the time being, we are not concerned with the promotion.
yes,
Whatever it may be, because you are not there. See, it is different channel. Therefore, if the applications are called for, is it possible to exclude or prevent the judicial officer from participating.
That's the question.
That's one part.
Yes.
What the other way around it is at 309, whether we can have a reservation for the law, it's something which is not even concerned, we are not concerned with that. But what we are trying to tell you is that this is, you are stopping with respect to the eligibility.
No, what,
Reservation is something different. That when this is after participation, when reservation might come. For whether you can have horizontal or vertical, you can have it.
yes.
But you just
No,
stop.
no, my lord, that's what I'm saying,
Yes.
my lord. Suppose, so my lord, 233 leaves exclusive wisdom to the high courts to decide how much, what is the eligibility for the judicial officers are concerned, from what stream to what extent I have to take. Suppose the high court decides we will take 75% or X percent, I'm saying not 75 because all India judges has come, X percent from the judicial service and Y percent from direct from advocates only. Can the insert,
Can you stop the mode of recruitment from one group from being participate in the mode of recruitment?
my lord,
Again, we are repeating the same thing.
my lord, I'm so sorry.
Too dangerous for us to hold.
No,
To
my
say
lord.
that they will not be even eligible to have.
No, no, what, I'm so sorry. What I'm submitting is for your lordship's consideration. If- What I'm I'm so sorry. What I'm submitting for lordship's consideration, can the in-service candidates claim we have a right on the 100% of the posts?
No,
Or whether they can say,
that is not a question. The question is whether for direct recruits
yes,
from the bar,
yes, my lord.
whether the otherwise eligible candidates who are in service, can they be excluded?
My lord, I'll put it other way around, my lord. Suppose the rules are silent. High court, it is up to the high court.
They are framed because
No, my
of
lord.
the commission.
No, my lord, so I'm saying let's test the proposition pre-Setis commission. The High Court rule says that we will appoint X percent from the judicial service and Y percent exclusively from advocates. Can such rule of Y requiring exclusively from advocates be struck down as a violation of 14 or 16? Can the right of the judicial officers in service say that our right is violated because certain number of posts are given only to the advocates? Lord, if the answer is no, all I'm saying is, Lord, it is up to the High Court to decide. The Constitution
The
233.
High Court, then if the High Courts have decided
Yes.
only on the basis of the
No, my lord,
All India Judges Association,
with great amount of respect, my lord.
because in both the cases, in both first two constitution bench judgments,
Yes.
the rules permitted, insofar as direct recruitment of district judges is concerned, both the streams to apply.
No, my lord, that is for the High Court to decide, my lord. If in a given case,
Therefore, we are considering whether
Ah,
the bar which is now
under the custom.
which now is there,
by Dhiraj Moore, which is imposed, that no in-service candidate shall apply
No,
from
my
that category, whether
no,
that is
with
correct
great
or
amount
not.
of, as has been pointed out by Mr. Shiv Singh, Lord, that so far as in some states, Madhya Pradesh, for example, he pointed out that in the direct recruitment quota also, the members from the judicial service are allowed if there are no recruitment for 2 years. It is not a complete bar. What I'm saying, it is up.
By the necessary implication.
Lordship would leave it to the High Court to decide, my lord. That's what I'm saying.
We can't leave a question,
Yeah.
interpretation of
Then
330.
Dheeraj Moore will.
No, no, Lordship would interpret to say, I'm so sorry.
More thing, please.
Yes,
When somebody is promoted
yes, my lord.
mechanism,
Yes,
see, we'll tell you, by the time the candidate is promoted to the district judge, depending upon the peculiar facts of each high court.
Yes, yes.
Purushottam or Chief High Court.
please, your lordships.
In one high court, somebody will get promoted at the age of 52.
Yes, my lord.
In other high court, you will get it at 45.
Yes, my lord.
These are not different footings. See, the right to be considered for promotion, it's a different thing. Now we are on the entitlement of competing.
Yes.
Now, in the teeth of the constitutional mandate. So now, what you are saying is there's no parity here. If that is what you are saying accepted, only high court judges, only the director of Solomon will be the high court judges. Because when you compete, when we put it, let us say bar at 35 being the minimum age, somebody is appointed 36, 37, only those guys they are now no promoter will get it. That's what is happening now. Therefore, the channel is different. The upward mobility is different. to say,
No.
this is a post and you get it and
No.
you take it.
So-
You can take and adjust. It's
Okay,
not
then-
going to happen.
And then why should a merit be compromised?
Yes, my lord. Now, the question of merit is concerned, so far as, my lord, the in-service candidates are concerned, their merit in the limited competitive examination is available. They can jump the queue, my lord, not necessarily wait for a turn in the order of senior.
And also you have to wait for a particular number of years.
No, that is in 3 years, my lord.
No.
5 years.
See, you don't.
5 years of civil just senior.
I'm
My lords, no.
the author of the judgment.
You say you don't appreciate what happened.
Of course, my lord, lordship has said that,
Now,
that.
frustration gets in there.
Let us-
Because it says, the judgment says, senior, civil judge, senior division,
Yes,
and there itself is, with a fairly senior,
my lord.
which means the person who is from the civil judge unit division, which is, let us say it's a magistrate level,
Yes, my lord.
he will become a sub-judge, then he will become CJM. Only those persons who alone will be allowed.
My lord.
Again, it become academic actually. See, somebody who would get before 1 year, other will get it by a matter of.
No, my lord, there, in LC quota, persons much junior comes in, lordship, no.
About LCE, we'll tell you.
My lord, persons who are,
Sorry,
much-
hundreds.
who are junior in the senior division, my lord, civil judge senior division, they come in LC quota.
Therefore, we doesn't facilitate, let us say somebody is
No, my lord.
civil judge unit division.
Yes, my lord.
If he is there for 8, 10 years,
Yes, my
he
lord.
cannot be allowed to write this limited competitive examination. He can't. That is only, again, there's a, of course, it's judgment.
No, lord, then what will happen, if your lordship permit this window, even the civil judge junior division can compete. my lord.
of course,
He
yeah,
can
but-
compete. Lordship would see this.
If he qualifies.
No, my lord. Yes.
So whatever, if he qualifies and if he is meritorious, then why should he be deprived?
No, my lord, question is, my lord, then your lordship see the, in this,
You know,
what happens in the service, my lord, within the service.
the answer here, I will
And-
give some ground realities.
Yes,
We have had instances that certain candidates failed in the examination of JMFs,
yes,
and many of them were selected. Then after few years, the candidates who had failed in the JMFC examination, they are permitted and they become district judges.
yes.
So you see the heartburn in a heart of a person who,
Well, there is a heartburning about, my lord, even the civil judge becoming a district judge over the, my lord, senior judge.
Sanjay, please appreciate, why we are saying is not in the point of view, see, there is nothing
No.
today, you should not look at it from the point of your lawyers or.
Yes, my lord, I'm not looking from the point of view of lawyers, my
You
lord. I
only,
represent
there
the
you
High
look
Court.
at it, as Honorable Chief said.
My lord,
You
yes.
only look at
Getting
it.
the best at trial.
From the
Yes,
ma-
yes, no, this is an institution which has to be.
This is the
vibrant.
institution, my
See,
lord.
now, you have to make sure that the bottom is, you are of a pristine quality.
Yes, my lord.
See, now, in a multi, hierarchical
Yes.
structure like us,
Yes,
where we have different tiers of scrutiny,
yes, my lord.
which is again one of the criticism against us. If you ensure the quality at the bottom, which would attract the best of the legal mind
Yes.
at that stage, then we have to facilitate it in the teeth of but the Constitution does not prohibit it so. So therefore, see, we have to move away from our mindset, from either being judge-centric or even lawyer-centric,
Yes,
from the litigant-centric.
yes.
You treat it like a commodity. See, rendering justice dispensation is a commodity. Therefore, we have to attract the best of the talent.
Please, your lordships.
For this, that is exactly what the Constitution mandates.
Yes, my lord.
Now,
My lord, to attract the best, my lord,
we are only trying to.
no, my lord, my lord, High Court would be conscious of taking a decision, my lord, whether they should allow, they should not allow. Because if the High Court themselves can allow it, my lord, all that I'm requesting,
if the High Court can be conscious of it and if it has to be left to the High Court,
yes, my lord,
then whether the judgment
because, I'm so sorry,
says that the in-service candidates are not permitted,
yes,
then does it not take away the decision of the High Court?
Yes.
If your argument is to be accepted.
yes. No, if your lordship, see the Chandra Mohan lordship has seen section 14,
If Dhiraj Moore is held to be valid,
yes.
then does it not take away the decision of the High Court?
No, my
High
lord,
Court would not be, High Court will have to say now that 25% is only for bar candidates, no person in service would be entitled.
yes, my lord.
So you are arguing.
No, I'm saying alternatively, my lord, what Mr. Gupta has said and what Dheeraj Moore has said, my lord, they cannot be. Dheeraj Moore said they cannot be. What I'm saying alternatively, leave it to the High Court because 233 does not prohibit.
No difficulty. The High Court under 309
Yes, my lord, 233 and 309, my lord, 233 is the mandate, my lord. Yes,
would be entitled to frame the rules.
yes, my lord.
But now the high courts have no discretion.
I agree, my lord,
High court discretion
Ah,
has been fettered. in
by the
view of
Dheeraj More judgment, by the Dheeraj More. That's what I'm alternatively saying, my lord.
Notice, we only put it to you from your perspective.
Yes,
It is well open to you to contend.
yes,
See, now after the two judgments, the two judgment of the Constitution Bench.
yes, my lord.
Then to say that there is no eligibility or qualification prescribed in the 233(1), which is again reiterated again and again.
Please, your lordship,
Sure of the thing.
my lord.
Therefore, you can say either leave it to the High Court with respect to the eligibility or qualification criteria, or we can be on 142, 100, which is,
Because,
and we can lay it down.
yes,
To that extent, we agree with you. You can say, so that either we can bring a parity, or we can take into consideration of the 25% quota.
what should be the minimum required for service and what should be the
To
minimum?
that extent, we'll
My lord,
appreciate.
why, my lord, the Chandra Mohan upheld it? Because lordship has seen, Chandra Mohan in direct recruitment provided both. Lordship has, my lord, the Chief Justice has said.
Provided both, but it's set aside on the ground, only on the ground that it was not restricted only for judicial officers.
No, that's
So,
what,
but
no,
even a
that's,
police officer or a revenue
no,
officer.
that's what exactly I'm submitting, my lord. Chandra Mohan provided direct recruitment from both the sources. Lordship would leave it to the High Court to decide whether both the sources or exclusively one source.
We are only answering the questions
Because,
which are referred. Thereafter, I will be honest, we have to frame the rules.
my lord,
What?
my lord, Lordship would not
No,
mandate,
we understand.
so long as your Lordship leave it to
You
the High Court.
consider an anomaly. A Naib Tahsildar
My lord,
is entitled to appear for IAS examination even if he is in service.
my lord.
Or a police constable, if he is otherwise qualified, he can directly compete for IPS.
My lord.
Is there a prohibition?
No, there is none, my lord.
We have our security guards here.
Because there is no quota, my lord. The difference is in
We
this
are not
sense.
saying quota.
High Court may decide, my lord.
Where is the quota? Quota.
No, no, that's what-
You are trying to build the,
No,
reach
it
the
is the
quota.
High Court to decide, my lord, whether we want it.
That we have to say.
That's all.
I could may decide.
My lord, my endeavor is only, Lordship would leave it to the High Court. Suppose the High Court says we want only 10% from lawyers.
Two difficulties.
What-
There are two difficulties, as Honorable Chief Justice said.
My lord,
If we agree with you, then we have to say, now the judgment of Dheeraj More is wrong.
No,
Then
to-
only one number one.
I understand. my
Number
lord.
two, what you are saying, the quota is not there.
Yes.
Quota is pretty much there.
No, quota is there under the, my lord. Yes.
In normal state service, what we are saying is, now, as Honorable Chief was saying about the constable thing, you will find all our security guard, other security personnel, evening time they will read. They will read and work for Group 3 service, Group 4 service, from being a constable. All of a sudden, some of our persons, young person working with us, he will become a sub-inspector or DSP by writing
My
examination.
lord.
So-
Last week, we felicitated one of the class 3 employees in the pharmacy
Yes.
who has been selected as an IAS. And
It's quite, my lord, that's what I'm saying. My lord, in IAS, there is no two branches who are going there, my lord.
Two branches are there. See,
No.
one by promotion.
One by is
See, one to see for
district-
a district superintendent of
from the
police,
districts,
he
yes.
becomes a superintendent of
Please,
police.
your lordship.
The other will come directly. So
My lord.
it's possible now.
My lord, that's what I'm saying. My lord, Lordship would not mandate, my lord. My lord, why I'm saying the High Court must have primacy, although historical, yes, very well, my lord.
But then your argument is on a different line that with Mr. Siv Singh and Mr. Gupta here.
No, I'm saying alternatively. No, I'm saying alternatively. I started saying.
No, he should have been in a place where normally Mr. Gopal Shankar Narayan sits.
I started saying, my lord, alternative to my learned friend Mr. Gupta's argument, I appear for the High Court, my lord, I have no interest in whether the judicial officer, etc. Am I seeing, my lord, that the High Court, the Constitution mandates, my lord,
High Court's discretion cannot be taken away.
High Court discretion either way, whether they want a particular percentage, one way or the other, my lord, should be left to the High Court alone.
No doubt about it.
My lord,
At
and-
the same time, whether the embargo which has been created by
But Dheeraj More,
needs to be maintained or not, then
my lord, that's right, my lord, alternatively, again,
Criminals.
my lord,
Already are.
and the reason why I'm saying, my lord, historically, let me just explain to your lordship, lord. Under the Government of India Act, Section 254 required the governor exercising his individual judgment.
Government of India 1915 or 35.
1935, my lord.
So that individual decision has been taken away.
that discretion of the governor has been taken away and the High Court decision has been made final.
Because of Article 50.
My lord, Article 50 and 233 has been interpreted as Balmukunsa, my learned friend Mr. Nidesh Gupta has extensively said.
Satraman itself deals with it.
And my lord, High Court,
It's about,
my lord,
The independence of the-
because so far as
that's the reason why that
my lord,
it was read into it.
what is important is 234 also. 234 judicial officers other than district judges includes Public Service Commission also. Here there is no Public Service Commission. So far district judge is concerned, High Court is the sole decision-making authority. My lord.
Consistent view.
No, my lord, I'm so sorry.
That's a consistent view.
Now, that's what I'm saying. So far as two district judges are concerned, Lordship would not hedge anything, my lord,
We are
with the
in
discretion,
we are
with the
in
wisdom of, the-
view that the supremacy of the High Court should not be taken away,
yes.
saving the rule. But at the same time, whether the discretion of the High Court could
No.
be fettered by Dheeraj Moore, that's a
No,
question.
no, my lord. Then your Lordship would leave to the High Court whether they
They are
want.
here only to answer.
No, I'm just responding to what has fallen from the court, my lord. Would leave it to the High Court that they would be eligible or they can exclude it if they want. If they want only advocates to be done, because my lord, 233 does not give a right to the in-service candidate
Already.
for a direct recruitment. It does not give, unless your Lordships holds.
233 does not give any right to anyone.
Yes, my
It
lord.
only Provides,
It does not give any right, my lord.
provides a source of entry.
It does not give any right. It provides eligibility to these advocates. In that event, Lordship would leave it to the High Courts whether they want advocates plus judicial officers and direct recruitment, or they want, my lord, judicial.
So you will be answering the questions.
Your Lordship would answer the question by taking, my lord, leaving it completely to the High Court. Then, my lord, if your Lordship says that they cannot be excluded, then there is a little issue, my lord, which I have made respectful submission. My lord, I have only another 3 more minutes. My lord, as I requested, Lordship would give 5 minutes each to my 2 colleagues, my lord. After, because I have time till 2:10.
Okay.
My lord, para 2,
We appreciate your generosity.
no, my lord.
You should
It's
encourage
our
the-
duty, my lord, to,
Encourage the younger members of the bar. That's why we are now, I think.
I made them prepare whole night, my lord. And
The court
I-
has now stopped mentioning by the seniors.
Yes, my lord, Lordship has. My lord, in my written submissions at para 20, I have given, my lord, 8 reasons why in-service candidates should not come in direct and it should be left to the High Court. That's one. And so far as, my lord, the stare decisis is concerned, my London friend, Mr. Singh has gone into the latest judgment of my lord, the Chief Justice State of Haryana. I have given in my written submissions, my lord, the citation is,
I have also given reasons as to why the stray decision will apply there.
no, my lord, we have given. And one last request, my lord. Chapter 6 of Part 6 of the Constitution starts with the subtitle, Subordinate Courts. Lordship, my lord, may consider. Lordship has said they are not, should not be called, sir. It's up to the Parliament. Lordship may express that whenever the Parliament considers, it should be district courts, my lord. Lordship may make some observations at some point in case, because to say that they are the subordinate courts is, my lord, is not very befitting to the district judges. It comes under the heading subordinate courts. Lordship may consider it is, of course, up to the Parliament to do it, my lord. But then some observations from your Lordship's court would, my lord, definitely help that, my lord. And my written submissions are given the historical perspective, my lord. And in the historical perspective, only one more thing, my lord. 209 capital A, which has become 233, was not part of the draft constitution. It has come in on the recommendation of a committee of the Federal Court Judges and Chief Justices Conference held in, my lord, March 26th and 27th March 1948. It is only on the recommendation of the Chief Justices Conference and the Federal Judges Conference that 209A to 209E, which has become 233 to 237, has come in. And where they emphasize that the High Court should be the fully wisdom as should be given the supremacy, my lord, of to decide as to how.
Consistent law, yes.
No, my lord, I'm saying that historically, it is not part of the draft constitution. 233 to 237 were not part of the draft constitution framed by the drafting committee or framed by the first constitutional advisor. It has come because of a conference, because, my lord, after the draft constitution was circulated, there were comments and suggestions from various sources. And, my lord, there was a meeting of the judges of the Federal Court and the Chief Justice of the High Courts on 26th and 27th March 1948.
That you are given in your written.
That I have given in my note, my lord. That on that basis, the suggestion was there.
Paragraph.
My lord, in my submissions, para 6 to para 12. of my submissions, my lord. And given the details of Siva Rao's book, my lord, from where it is enumerated.
But I don't agree with para 20G.
Yes,
Para 20G.
Yes.
Allowing the in-service candidate to compete in the direct recruitment quota would have an adverse impact on the functioning of the courts, as judicial officers would devote more time in preparing for the examination at the cost of judicial work. This is what is this? High Court is saying all this.
Very well, my lord. That perhaps is, I also, my lord, perhaps.
I recollect the comment made by Justice Vinod Chandran on the first day, but
Yes.
because of social media, we refrain.
Which we will never hear about.
Maybe some evening, yeah.
Yes.
Lordship, there is the humble request for my argument. If that side was,
My
Please
lord,
consider if that
give
side
me
will
a note with reasons.
For at 2 o'clock.
Oh, you have finished yourself. Yeah.
Lordship, humble request for my arguments. If that side.
Lord, you would hear Mr. Gupta, Mr. Sharma also, if he gives a two-page submission, my lord, all that he says, it may be decided. If he gives some, contribute something,
How-
definitely, my lord, he should be given
How can
chance.
I write my argument in my submission?
Yes.
That is the.
Please, your lordship.
My learned friends start. Lord, would your lordship give us 10 minutes at the end just for a very quick, my lord, clarification on 2 or 3 points that they've made?
Subject to when they finish.
Lordship. Would your lordship permit my friends to just adjust for 5 minutes?
Yes.
Milords, I second what all my learned seniors have argued on this side. Milords, I have 3 more points to state.
What is your good name?
Sorry, Milords?
Good name.
Kavya. Milords, Kavya Jawar.
Avya.
Yes, Milords. I'll just pass the.
Ask next one.
Milords, the very first point is that the Constitution of India has used the expression has been at 50 places, including Article 233, Milords, which I have mentioned at Schedule 1 from pages 2 to 4. Milords, my submission is that has been means something which is continuing, and it cannot mean something that has happened in the past or at some point of time. Because, Milords, if that expression, if the meaning of has been would have been that, then the entire structure and for behind which the provisions have been brought into force would be frustrated, Milords. That articles I have mentioned from pages 2 to 4, Milords, 50 articles. Secondly, Milords, clause 1 of Article 233 has used the words appointment, posting and promotion. Milords, my submission is that all the 3 words have to be juxtaposed and read together and not in isolation to give individual meaning to each of the said word. Milords, there is a reason why promotion and posting was not deleted even after there was a specific amendment moved in the CAD, Milords, and that should be taken into consideration, is my humble submission. Clause 1 deals with promotees and clause 2 deals with direct recruits, that too only for.
That's already been argued so many times.
Yes, Milords. And Milords, the third point is that clause 2 uses the word a person not already in service of the union or the state. Milords, had the constitution intended to include in service, it would have been explicitly mentioned. Milords, in schedule 2, which is at page 5, I have given a list of 15 provisions which by way of proviso or explanation have included the word include to mean something more when the constitution intended to. But Milords, when it is not used in Article 233, it has to be given a restricted meaning and not a wider interpretation, Milords. These are my submissions, Milords. Much obliged.
Thank you very much. Very well done.
There's another colleague of mine, Lord, which is assisting. Give your written submissions. Give your written submissions.
Your Lordship, in light of the
Let's proceed in.
So, Your Lordship, in light of the comprehensive submission which already my senior has made, I have I'll just confine my submission to 4 heads which I have already circulated. Firstly, the constitutional scheme and pivotal role of the High Court. Under Article 233 and 234, it's a self-contained code. Yes. And this principle has been very well recognized in the case of Mukund Saha versus State of Bihar, which has very clearly said that well-knit and complete scheme,
which is insulated from legislative or executive interference. When we say that, it shows that the High Court has the exclusive and a pivotal role to play. Secondly, there is a constitutional bar against any aggregation of experience. There is a categorical bar as to say, under Article 233(2), it has been stated that a person not already in the service of the union or of the state can be considered for direct recruitment only if they have been an advocate for not less than 7 years. That is immediately and continuously before the cutoff date. And when aggregating periods of past practices with judicial services is involved, in that sense, the plain text of 233(2) is violated. And secondly, the principle of exclusive recruitment streams also come into picture, which again gets violated. And thirdly, I would like to state that the constitutional design that candidates in service compete only through promotion can never be mixing with the direct recruits. Fourthly, I would like to conclude by saying that I am squarely covered by the principle of stare decisis.
That your senior has also very ably argued.
Yes, Your Lordship.
Also, the earlier two concepts.
Yes, Your Lordship. I'm grateful. Your
Thank you very well done. We appreciate Mr. Ansari giving an opportunity to
Here, Dr. Vivek Sharma also at some point of time, Lord, he should not go with a grievance, Lord, at the end, Lord, towards the. Nobody should go from the court without any grievance not being heard.
Yes, exactly.
And encouragement.
We are happy to go home, Mrs. Shah.
Yes, may it please your lordships. My lords, I have the pleasure of appearing for the High Court of Madhya Pradesh in item number 501.6, my lords. 501.6. Lords, I wholeheartedly adopt, my lord, the submissions which have been made so far by my learned, my lords, friends on this side. And those submissions, if I may say so with respect to your lordships, have been really very persuasive and throw some very serious thoughts about the, my lord, the understanding of the constitution. So, my lords, I would adopt. At the same time, I am perplexed, my lord, what more can I really add to it, my lords? And when I have to mark my presence, my lord, but I have to speak few words.
With your rich experience.
I have to speak few words, my lord, so that your lordships. My lords, the High Court has made a submission, my lord, it's on the already in the court. But I have prepared my own, my lord, 2 or 3 pages, my lord, we have tried to call out, my lord, the real questions which arise. If your lordships would please permit me. Which not this one, supplementary submission. But they are styled as supplementary submissions, my lords.
There's one brief submission and one supplementary submission.
Yes, supplementary is, my lord, mine, so that is in response to the, my lord's questions or the observations which have been arised.
Supplementary or the brief?
Supplementary, my lords. That would be better because then only I can adhere to my timeline also.
Yes.
Now, my lords, my first submission is this, my lord, that both the Constitution Bench, judgments in Rameshwar Dayal and Chandra Mohan, are not authority for the questions which have arisen for decision before this bench. Whether or not a sitting civil judge is entitled to seek direct recruitment as district judge, never directly fell for consideration before the court in those cases. They have not even been directly or indirectly perceived as the questions arising for an authoritative pronouncement. A careful reading of both the judgments would show the decision turned out entirely on peculiar facts of those cases, rather than laying down any principle of law with respect to the questions framed herein. The passage of Rameshwar Dayal is being incorrectly read to argue that for in-service candidate no qualifications for direct recruitment are provided. Such observation in the judgment of Rameshwar Dayal is in respect to appointment under Article 233(1) and not 233(2). Article 233(1) deals with promotion as one source, whereas Article 232 deals with another source, which is direct recruitment from the bar. and for this reason, condition of eligibility under the Constitution has been provided. The submission that the absence of qualification observation in Rameshwar Dayal is only in respect of appointment within bracket by way of promotion bracket closed as district judge is further reiterated in Chandra Mohan case, and it has been categorically observed under Article 233(1) in the matter of appointment of district judge. The said article does not lay down any qualification for the candidates to be appointed or even denote the source from which recruitment is to be made. Therefore, the submission is that absence of qualification under the Constitution observation only pertains to appointment under Article 233(1) and not 2. However, it is submitted that as the recruitment rules can be framed, that is under Article 309 in consultation with the High Court, and have been framed in all these states. The qualifications for appointment under 233(1) by adopting the mode of direct recruitment and promotion are governed by the rules which are in force. In Rameshwar, all 5 were appointed by way of direct recruitment from the bar, and the question was whether they complied with the qualification under Article 233(2). 3 of them were actually practicing advocates at the time of appointment. In their regard, the question was whether their period of practice in Lahore could be considered. The other 2, Harban Singh and P.R. Sahni, did not have their names factually on the roll of advocates, which led to the argument that they were not eligible as per Article 233(2). The only point that fell for consideration was whether those 5 appointed district judges fulfilled the requirement of Article 233(2). The question has been answered by the court in 2 different parts and mostly on the facts appreciated in the light of historical background and the relevant rules. All 5 appointments were upheld as they were found to be practicing advocates, 3 actually and 2 notionally, my lord, that is Harban Singh and Mr. Sahni. The question which the Honorable Court is considering whether in service incumbents are eligible to be considered for appointment directly as district judges never fell for consideration or was perceived in both the earlier Constitution bench cases. Chandra Mohan case only considered the meaning of service and interpreted it to mean judicial service. For the first time, it arose directly for direct consideration in Satyanarayan Singh in 1985 and in subsequent decisions. In addition, it was considered threadbare by the Shetty Commission report, which submitted a lengthy report on this vital issue recommending amendment in the Constitution. The report of the Shetty Commission, which has been accepted by this Honorable Court repeatedly, itself recognizes that in order to enable in-service candidate to apply for direct appointment as district judge, constitutional amendment would be necessary inasmuch as the existing provisions of the Constitution do not provide for the same. It is respectfully submitted that without the constitutional amendment, in the garb of interpretation of the Constitution, a new provision cannot be enacted as it would amount to judicial legislation. It would be against the constitutional doctrine of separation of powers. Since the Constitution bench judgment is not direct authority on law as far as the question of allowing in service candidates to apply for direct recruitment as district judge, the only decisions which perceive this issue in a direct manner are the decisions in Satyanarayan Singh, Deepak Agrawal, and Dheeraj Bormelot, and Sushma Suri also. Satyanarayan Singh, read in the background of Rameshwar Dayal and Chandra Mohan, have held at the field. They have held the field for more than 40 years, and the requirement of the decision of state decisis.
Stated decision has been extensively argued by.
Should be, but I have a proposition, my lord. Yes. If a plausible view has been taken on the aforesaid decision, which cannot be said to be in direct constitutional violation of an express provision of the Constitution, this court should be slow in reconsidering overturning the settled position of law, merely because it is likely to bolster up career prospects of some ambitious in-service candidate is no ground for reconsideration of the judgments. My lords, the submission that I wish to make is this, my lords, which I have not articulated here. Your lordships are proceeding on the basis, as I have understood, my lord, that 233(2) does not provide for disqualification. There is no exclusion under 233(2) for
There is no quota card out for.
There is no, my lords, prohibition under 233(2), my lords, so for in-service candidates. But, my lord, that may not be with greatest respect a right understanding because of the words used, my lord, in the same, my lord, sub-article has been. The real problem, my lord, for the other, my friends, my lord, on that side is not, my lord, Dheeraj more. The real problem, as I understand, is, my lord, the interpretation placed upon the words has been. My lord, in Deepak Agrawal's case, which is a bench of 3 judges. If has been interpretation of the meaning which has been assigned by decision of this court, to which, my lord, no fault has been found so far, which means, my lord, has been means present past continuous. That means as advocate, he must be practicing on the date of the application, my lords. If I may just place that judgment of Deepak Agarwal, or your lordships may only note the paragraph, para 102, my lords, which is of the judgment, which is para 88, 88 in your lordship's volume, my lord, page 744, volume 5.2. My lord, may not open it, my lord, but allow me to only read it, how they have, my lords, articulated this part. The lordships have said, as regards construction of expression, if he has been for not less than 7 years or an advocate, in Article 233(2) of the Constitution, we think Mr. Prashant Bhushan was right in his submission that this expression means 7 years as an advocate immediately preceding the application and not 7 years at any time in the past. This is clear by the use of word has been. The present perfect continuous tense is used for a position which began at some time in the past and is still continuing. Therefore, one of the essential requirements articulated by the above expression in Article 233(2) is that such person must, with requisite period of continuing as an advocate on the date of application. So this is the prohibition. The word has been is the prohibition. And it flows from here. The other part of the submission, which I was wondering myself,
Which is the paragraph that you read from Deepak Agarwal?
this is para 88 in Deepak Agrawal in your lordship's volume 5.2 at page 744. My lord's a judgment by a bench of 3 judges, my lord, learned judges. That's my lord. So if this word has been, has this meaning, my lords, that he must be a practicing advocate on the date of the application, then, my lord, the prohibition creeps in, that it comes in. It has to be read in, and it has been so read. Then they are not entitled, my lord, to apply. The second thing, my lord, which I was wondering as to why in the article scheme of Article 233, there was 1 and 2, two different expressions have been used, my lord, so far as the role of the High Court is concerned, my lords. In first part, it is consultation is, my lord, the word used in consultation with the High Court. The governor is the appointing authority, that's a general declaration. Is the appointing authority in regard to the appointment to be posting and promotion of district judges. How that has to be done is in consultation. Whereas in contrast, your lordships will notice in sub-article 2, my lord, the word recommended by the High Court has been used. My lord, I was trying to, my lord, find in my own humble way, my lord, a meaning to this, and my submission is this. And that's an indicator, my lord, that the promotion will take place under sub-article 1 only. Promotion will take. Why? Consultation is a word, my lords, of a lesser import, of a lesser, my lord's, strength, as compared to recommendation. Consultation may be binding, may not be binding, but, my lords, in the case of High Courts, your lordships have always said that it is binding. I assume that it is binding. But it remains consultation when the Constitution was framed. Why? Because, my lord, all the incumbents who are in service, they are within the control of the High Court, under the control of the High Court, 235. Their service records, everything is available. The High Court knows who is what. Their services, my lords, every particulars are available. So, my lord, a word of minor, my lord's, import, that is consultation, is used. My lord, that is indicative of the fact that 2 promotions will take, my lords, only, my lord, in the stream under Article 233(1). Whereas, my lord, when in contrast, the word recommendation has been used in Article 2 by the High Court, That means, my lord, recommendation has some persuasive, my lord, some authoritative, my lord, push behind my lord's recommendation. Is a stronger expression than consultation. Recommended.
Are different.
Yes,
It's only for, we can just loosely call it as.
no, the words are not wasted by the constitution makers, my lord. We will assume that they made the choice of the words carefully.
No,
But when my lord,
certification.
the words recommended is used, that means a person is being recruited from outside. The High Court does not know only through the, my lord, the selection process. So it is in that context, my lord, the word recommended has been. So, my lord, that may be one indication, my lord, with regard to this. Now, my submission, my lord, is this. Ever since the Constitution has come into force, number of decisions have taken place, and this position of law has been settled. On that basis, my lord, the Shetty,
That is everybody's argument.
Your argument is,
I'm trying to say something, my lord, and I know that this,
Sir, your argument is contrary to what C.U. Singh and said and others.
not at all, not in the
Tell you
least,
why.
my lord, it
I'll
is
tell you
simply.
why. If you say Rameshwar Dayal and then Chandramohan do not lay down the law.
I do not say that.
But do not say.
No,
They are
do not-
dealing with some other issue. The fact,
I'll show that, now. Let me.
we'll tell you why. The fact remains, at least till the decision in Chandramohan, yeah, and even thereafter, till,
I
till
know, my lord, something
Till
very
this
interesting.
subsequent judgment in Satyanarayana has
Just
come into being,
Your lordship, my lord, something.
we just tell you on the status, presumed statuses, it was not there from day one onwards.
Sorry.
From day one onwards, right from 1938 Act and also after the Constitution, it is not as if lawyers alone were allowed to compete in the direct recruitment. It is not that.
I'm not.
Origin, we tell you because on the principle of statistics, you are saying that what is settled should not be unsettled. That principle will not apply for more than one reason because originally they both of them were allowed. It is only after the judgment of this court only that the problem came.
Dheeraj Moore, your lordships.
That's correct. There is more even you include Satyanarayana Prasad. Therefore,
National
My lord, I believe, my lords, 1985 onwards, when Satyanarayana Singh authoritatively
therefore it's
said,
not as if it has been there.
Satyanarayana Singh in 1985 turned down this argument, my lord, formally by saying that the in-service candidates can also apply for direct recruitment under 233(2). I don't think, my lord, ever anybody would have flouted this law of this land, my lords, after 1985. I'm not, my lords, I don't have the status in the facts, but in 1985, this is Channappa Reddy, my lord, said that it may not, that cannot be permitted in UP case to compete.
Right, at least till then.
Yes,
Till then the scenario was different.
so 1985 is 40 years, my lords. now.
Not from the beginning.
My lords, why I'm saying, my lord, that the question did not arise in, my lord, the question which your lordships are grappling with today did not arise either in Ramdayal or Chandramohan is, my lords. Please have my lord Chandramohan for a moment.
Then the principle of stare decisis can be applied when the law is expected to apply for a larger section of society. It is not meant for deciding a issue like this. Because what is in vogue to be applicable to every citizen, if you change it, it will create some
Exactly, my lord, yes. So
It's not that, it is only
that
mere.
that is why, my lord, that's the principle which state
Yes.
decisis. My lord, so note from Chandramohan, my lord, so lordship will please see from Chandramohan, my lords, that this question was raised in the judgment. Give me that. Page 82, my lords. Internal page 82,
Yes.
but not answered. My lord, if lordship will see the lordship's reference. Page 185 of my lords, the Chandramohan, kindly note that. Page 185,
Yes.
volume 5.1,
Yes.
185. Well, lord, the page, my lord, 185. That's, I'm referring to Chandramohan's case.
Yes.
Your lordships will notice the paragraph beginning with the sentence, the arguments of the learned counsel for the appellants may be placed conveniently under the following 5 heads. Then please come, my lord, between the placitum E and F. The head number 4. I hope your lordships,
Yes, the governor has no power.
Yes. Head number 4 is the question number 4. The exclusion of the members of the judicial service in the matter of direct recruitment offense, Article 14 and 16 of the Constitution. Well, Lord, this was question number 4. The Lordship stopped at question number 3, did not answer question number 4. Because in question number 3, the Lordship's answer was that service, my lords, in the context of 233(2) means judicial service, and that is where the judgment stops. It does not answer, it does not consider the question which was raised in this judgment. That is why I'm saying, my lord, that these are not the judgments for the authority, for the proposition.
You don't want to interfere, interfere when you are arguing, all of you are arguing. The Chandramohan itself premised on the footing.
My lord, if this question was,
Repeatedly we are telling, see, when it's suppose in the case of promotion, there's no need to interpret what is your union, what is service under union, what is service under state. Because once you have a structure, once you have a system for promotion, it takes care of it. It is only when direct recruitment came that the interpretation required. Whether any service under the state or central would come under the eligible direct recruitment. That's the problem. That's what we have been repeatedly telling. Chandramohan proceed, he was only concerned with a direct recruitment. It does not concern itself, Rule 14 is also the same. It does not concern itself with a promotion, because nobody is concerned with the promotion. No challenge would have come.
So-
Challenge itself, that is why they gave the interpretation. Because they understood that a service, somebody's service candidate also is eligible under the direct recruitment. Now, unfortunately, 1985, as you rightly said, that's where the other issue is started now.
so there,
Otherwise, everybody has understood that way. Because when judgment has come, it has taken a different turn thereof.
therefore, my lord, perhaps I'm right. With great respect, my lord, to your lordship, my lord, I'm right in saying that even though the question was raised directly, my lord, in Chandramohan, it was not discussed, decided, my lord, and answered.
Very good.
Whether in-service candidates are entitled, my lord, to apply for direct recruitment. And therefore, my lord, your lordships may independently, my lord, interpret the Constitution.
Yes, yes.
But so far as the question, my lords, which have been framed, my lords, are concerned, your lordships can take some assistance, my lord, from the observations made herein, but they are not, my lords, conclusive, those observations. Your lordships have always said, my lord, that a judgment is an authority for what it decides. Every observation, my lord, of the reasoning that is contained is not binding. What is binding is the ratio.
What we are trying
The
to tell you
ratio,
is that.
lords, please permit me, my lord, to complete.
All right.
My lords, what Chandramohan, my lord, holds it, my lord, the ratio, if I can say, of the Chandramohan is that service means judicial service, nothing else. That's the only ratio. That's only law declared in Chandramohan. Yes, my lords.
We'll consider that.
And the second thing, my lords, which has been quite, my lords, been impressing your lordships' mind, my lords, is that if a Tahsildar can compete for IAS or IPS or, my lords, a teacher or, my lord, a constable or some inspector, why not? My lord, they. The reason is this, my lord, there is no comparable analogy. Why? Because appointment of, my lord, district judge is governed by Article 233 of the Constitution in a particular way and manner. Appointment will go, my lords, to IAS and IPS and other services are governed by rules made under Article 309. They are not constitutional appointment. They are not governed by constitutional provisions. They are governed by the rules. So, my lord, that analogy may not be applied, my lords, and I think is not correct. My lords, all the conditions of recruitment, service conditions, everything is prescribed under Article 309 by framing rules. Either the rules are framed by the president or by the governor. President in respect of the union service, governor in respect of the state services. So that may not be the correct, my lords, approach. My lords, for all the other matters, my lords, I adopt the submissions, my lords. And I must say, I must compliment, my lord, that they have batted very well. And as a last batsman, my lords,
It's always
as a last batsman, I was not really expected to do much, and particularly, my lord, on a pitch. My lord, by playing on a pitch where the balls are bouncing so, my lord, fiercely.
In such cases, it's more difficult.
Also, in such cases, what happens? 5 runs required, 1 ball, he will hit a 6.
It happened, my lord, in the India-Pakistan match.
Kapil Dev.
My lord, India-Pakistan match, that player who became captain, my lord, Pakistan. Javed, he hit, my lord, in the last ball is 6, and Pakistan won a World Cup match. Anyway, my lord, I'm not that person. I'm not that, I have no qualms about my ability, my lord. So this is all as High Court I have submitted, my lords, and we have framed our rules, my lord. We are following the rules, my lords, and those rules are not in question. Grateful.
The lighter vein, my lord, Mr. Srivastava has declared the inning. He said he's the last man. I'm sorry, my lord.
Last but one, my lord. Last
Just
but
in a
one.
lighter, in a lighter way.
Last but one.
My lord,
We'll reframe this as tailenders.
We will hit a six, my lord.
no, with my lords, Justice Sundaresh being there, helming the cricket team, I know this is impossible. He's not only a good bowler, but a good batsman as well. So he knows how to defend and bowl googlies. Now, my lord, I know your lordships are exhausted. Most of the ground has been covered. But since it's my duty to present what I am being instructed to,
You are appearing for whom?
my lord, I appear for in 501.8 direct recruits in review petition for respondent numbers 3, 5, and 9. My lord, in keeping in mind the time that my lords have allotted, and I don't want to,
We are not allotted. That has been allotted amongst yourself by all of you.
Lord, with your lordships directions, we had to comply with it, my lord. And you have given it to the other side. In fact, my lord, there is a Greek character called Sisyphus. Today, respondents called Sisyphus, my lord. My lord, the respondents presently, my lord, because of the observations fee, he was punished by the gods to roll a stone up the hill, my lord. Every time he rolled, it came down. So I don't know where we are going. But please, my lord, can I just draw my attention to the written submissions that I have made, my lord? Just to...
All written submissions should have been part of the compilation because
Lord, I made it a little shorter so that what I'm going to, instead of Lord making a oral submission to a large extent, I just wanted to quickly run your lordships through this. And if necessary, I'll say whatever has to be said, my lord. But Lord, according to me, there are three categories that your seniors, that your lordships have to deal with. First, those who have practiced as advocates for 7 years or more prior to entering judicial service. Second, those who have practiced as advocates for less than 7 years prior to entering service, but covered the remaining period stipulated in Article 233, Clause 2, with their experience in judicial service. Third, those who have not practiced at all as advocates, but have been in judicial service for 7 years or more. But these are the three categories broadly that your lordships have to deal with. Now, insofar as the second and the third category that I have listed out, my lord, is concerned, it is my submission, my lord, it's our respectful submission, that those judicial officers who have less than 7 years as advocates, but cover up the deficit with their experience as judicial officers or have not at all practiced as advocates and rely entirely upon their experience as judicial officers, are clearly hit by Clause 2 of Article 233. Upon a plain reading of Clause 2 of Article 233, what emerges is that for a person to be eligible for appointment through direct recruitment route, he or she has to cross the following hoops. First, my lord, and that is what, as I read subclause 2 or Clause 2 of Article 233, he or she should not be in service of union or state, which is now settled and should be read as judicial service. Now, that is what has been held in Chandramohan. The person is an advocate or pleader, and the person concerned should have practice for not less than 7 years. So unless, my lord, insofar as category 2 and 3 is concerned, it is our respectful submission, my lord, that clearly one of the other condition is not fulfilled. Therefore, my lord, that's para 3. If a person is in judicial service, he or she is not eligible to take recourse to direct recruitment route, since such person shall fall on account of her ineligibility. Thus, logically, even if she or he were to clear the exam and interview, such person cannot be recommended for appointment as a district judge by the High Court. The judgment, my lord, we rely upon Satyanarayan for whatever it is worth. Your lordships have expressed a view, my lord, brings out this aspect quite clearly. As far as persons in judicial service are concerned, they can be appointed through promotion route, both by applying one of the two yardsticks, which is well known, my lord. Merit cum seniority or pure merit. The pure merit yardstick is available to those who take limited departmental competitive exam. Their appointment is made by the governor of the concerned state in consultation with the High Court. The qualifications are provided in the recruitment routes. The argument of the petitioners that permitting in-service judges to compete in direct recruitment quota, which up until now is available to advocates, because it would incentivize the talented ones amongst those who are in service, by opening up more avenues, loses, according to us, sight of the following. Lord, even today, a large chunk of posts, i.e. 75%, are available to in-service candidates, both through promotion and LDCE. Infusion of advocates at district judge level via direct recruitment aligns with the plain language of Clause 2 of Article 233. The submission propounded by the petitioners, although attractive at first blush, would lead to anxiety and disruption of career paths amongst those who are in service. For instance, my lord, this is an example that your lordship would like to at least examine.
But then that would also happen in LDC, LCD.
Yes.
If,
So, my lord,
if a junior person gets selected as a district judge over his senior, then that anxiety would also affect in such a case also. So then the LCD also has to go.
my lord, so therefore, my lord, the argument is this. My lord, the argument is this. I appreciate what has fallen from my lord. If you have the LDCE route, then you can upend someone's career by going through that route. But those two routes are available to them for in-service, as against those who are not in service. So, my lord, the concern, I'm sorry.
There also there is an embargo. Now we have provided some quota for civil senior division also. Earlier, they had to complete 7 years of practice for appearing. I think earlier it was 10 years. We have brought it down to 7 years now.
Yes, my lord, I am relying upon my lordship's judgment. In fact, one of my arguments in this submission that I've placed before my lords is that your lordships in the 2025 judgment, which is the 5th AIJ case, my lord, your lordships dealt with this aspect. Your lordship will remember that the LDCE quota was brought down to 10%.
From 25 to 10.
From 25 to 10. Your lordships said to incentivize, we need to increase it to 25%. So a sort of an impact assessment was done. So it is not as if, my lord, they don't have enough opportunities. What this court is being asked to do by the petitioners is open a third avenue, which according to us is a disruptor for two reasons, my lord. Your lordship may ultimately agree or not, which is that your lordships are called upon to, in a sense, read into clause 2 what is not given there plainly. 1. 2, my lord, it is our submission that this will cause disruption. The example that I gave, your lordships give a counter example, that is, my lord, obvious that as between those who go through the promotion route, seniority, merit comes seniority, and as against those who go through only pure merit, there is that race. But now you are also giving them an opportunity to get into direct recruitment. Apart from the fact that your lordships in the 2025 judgment, the 5th AIJ case, has A, increased the LDCE quota. B, your lordships have also said why experience even at entry level is important, that you should be an advocate. Now, please try and appreciate, my lord. And this is what I've said later on, my lord. At every level, your lordships have, or the constitutional scheme is such that advocates are appointed. Not the district level, because of Article 233, Clause 2. At the High Court level, the ratio is actually 2/3, 1/3. And then, of course, the Supreme Court, with a special dispensation under Article 124, that you can also appoint a jurist.
Why? So advocates are better than judges who are functioning at the district judiciary.
My lord, I am not making a comparison. But, no, my lord, I am...
It's like saying,
Sorry, my lord, your lordship.
A is better than B, unless you give the opportunity. That is exactly what we are saying. The idea is to empower the institution. Once you empower the institution, things might change. Yeah, to have the quality at the bottom is what we are saying.
My lord, please, can I know, my lord, what's going through my lord's mind. My lord, can I just say, when it was reduced from 25% to 10%, the experience was not good.
It's not a...
I'm just saying, my lord, it is not as if there were not enough opportunities, or there are not enough opportunities.
On the touchstone of basic structure. See, now, judging it is more like it's a calling.
Yes.
Departmental thing, you just go in employment, then you see, consider interest, seniority, I should come, you should come. It's not that. We are not, for the moment we are seeing the parties, we are not seeing the parties. We are only seeing about the constitutional mandate. See how the forefathers of the constitution thought about it. How to make sure that institution stays vibrant, which is at the bottom. The faith of the institution depends upon the functioning of the district judiciary. For that, you have to infuse more quality. More quality will come and more competition. So obvious, in the absence of any restriction of the constitution, we can't do it.
My lord,
We understand that you might
I
lose out something.
my lord, we understand what is following from my lords, my lord. But coming to para 8 of my submission, my lord, I want to refer to the Honorable Chief Justice's judgment, where your lordships have said what experience means of advocates, my lord. These paragraphs, I don't want to read it. Justice Chandran was also party to that judgment along with Justice Masi, my lord. Where your lordships have said why advocates are important in the system. Now, this has been the preserve of the advocates for a very long time. What your lordships are asked, my lord, your lordship said it was not there before 85, but 85 to now is a long period. With your lordship's judgment, increasing the quota for LDCE, it is our respectful submission, my lord, that your lordship should allow it to play out so that.
You just consider a situation.
Yes, my lord.
Even for LDC, he has required to, earlier the requirement was 7 years, 10 years. Now by this judgment, you have brought it down to 7 years.
Please.
Suppose if a candidate is at the bar for 5 years, he will be entitled to appear for LDC through only after he completes 12 years. And whereas
Yes.
a person from the bar would be entitled to compete against this 25% post immediately after completion of 7 years.
Lord, can I share an experience which, can I just, 35. But can I share an experience, my lord, which I'm sure, my lord, your lordships have far more experience.
35.
Actually, senior division, it takes 5 years and then 3 years. So in cumulatively comes 8 years for LDC.
No, we have made it 7 years.
MP, I could lose 5 years.
I'm talking about the judgment.
No, your lordships have made it 7, which includes a period as civil judge junior division. But
Unit division and
Not the experience is this. Even when we had this quota for LDC, my lord, we actually didn't get enough people. And which is why, my lord, it was reduced to 10. There is, I'm so sorry, Chief Justices. May I just respond, my lord? This is an experience which all of you have, my lord, and some of us on this side also have, my lord. When we tried to fill, because what happens is, my lord, when you're in service, somehow after some,
experience.
sorry, my lord.
You have a lot of experience also sitting on the committee.
Yeah, NCMS committee, my lord.
No, even that LCD committee.
Yes, my lord, your lordships are right, my lord. In fact, that report should be, your lordship should make it public at some time whenever your lordship thinks it's necessary. But our experience as, and if your lordship pardon me to get into that area is, when we asked for in-service candidates, how many of you want to sit for the LCDE quota, my lord? They didn't, because once you're in service, you're very cagey about taking an examination.
That situation in Delhi was, it's a very peculiar situation. I have considered in my judgment,
Yes, your lordship.
sitting with Justice Rageshwar Rao.
Your
Because by the time one became eligible to appear for LCD, he was already eligible to become through routine course. And therefore, initially we reduced the 10 years here, 10 years requirement to 7 years insofar as Delhi is concerned. And subsequently in that judgment, we applied it to all India, on pan-India basis.
No, that was one set of circumstances, with your lordships pointed out, my lord.
Yes.
Delhi had that particular, but your lordships have noticed in your own judgment.
No, that is another judgment. That is 3 judges. I am talking about a judgment which was rendered by me when sitting with Justice Rageshwar Rao. When we found that in Delhi, by the time you are eligible to appear for LCD,
Yes.
one is already entitled to be promoted through the regular channel, and therefore there is no incentive.
Your lordships are right. But
That's
if
the
from your,
that happened with most of my clients. By the time they were eligible to sit for LDC, they were already eligible under the promotion thing.
They'll be 40, 45, they'll be just doing
can I-
it.
can-
You want
Therefore,
small
we
incentive.
brought down that 10 years requirement to 7 years.
my lord, your lordships just turn to volume 5, 1150 of your lordship's judgment for a moment. Paragraph 18, my lord.
Volume 5.
Volume 5.5.3, where your lordship's judgment 1150, it starts at 1150 running page and it is at 1160 I know, but I'm referring to this. Where your lordships, my lord, while dealing with this business of increasing the quota, noted this in paragraph 18. My lords, the Honorable Chief Justice, just have a look at it. And today, my lord, with respect, the petitioners have not given you any empirical data, my lord.
Rajiv, what is the total number of judicial officers in Delhi?
Lord, in Delhi, there would be about, I don't have the current figure, but I can. Huh?
Approximately.
Lord, there would be about 6. Is it? 500 something.
The internet is showing 60.
Yeah.
You wanted to clarify.
I will give you the.
More than 100?
Yes, my lord.
All put together.
Yes. No, it's much more than 100. It's actually 700 additional district judges.
700?
Yes, my lord. And 350 metropolitan magistrates across districts, my lord. So it's a city state.
The reason why my brother is asking the question is this.
Yes, my lord.
In that direct recruitment,
Sorry, my lord.
that direct recruitment post for the district judge,
Yes, my lord.
in every state, there will be eligible among the district judiciary will be 100 or 150, where lawyers will be applying to the 1,000, 2,000 or 3,000. What is a big deal that's going to happen to you? This is what my brothers want to say. Nothing much.
Change.
You have 35 years minimum, then there will be qualification. Let us assume the symbolic way. There will be about 100, 150 people. Why you feel shy of competing with them in the open category? Is what my brother is saying. You see, nothing but apprehension, nothing else. We'll tell you why. You also would have seen it. Most of the cases, the director could be not able to fill it up. At least now, someone else will be qualified to come. Let us take it for an example, for statistics, if you take throughout the country, in every high court, every year selection for district judges, director recruit. If you have 15 vacancies, only 5 would be able to be filled up. It is not that they are going to be standing in competition for you.
My lord, on the same note, can I just show this, my lord? Paragraph 18 of my lord's judgment, my lord, where your lordships noted the position of some of the high courts. My lord, in the middle, paragraph 18, where your lordship said, my lord, the Chief Justice has it.
Yes.
Some of the states also face difficulty that sufficient number of candidates were not available for being promoted under the, does my Lord Justice Sundaresh have it?
Yes. Paragraph 18.
Yes, ma'am. 1160, my lord.
Yes.
In the middle, some of the states, does my lord have that?
Yes.
Also face the difficulty that sufficient number of candidates were not available for being promoted under the LDCE category from the cadre of civil judge senior division. So the point that I'm making is, my lord,
No, that was why the 25% quota was reduced to 10%. And thereafter we had elaborately called for the responses from all the state governments, high courts, and thereafter we found that now there was a sufficient feeder strength to compete for 25% LCD quota, and therefore we increased it to 25.
No, and therefore, my lord, in paragraph 20, the next page, your lordship said, since with the passage of time, does my lord have that?
Yes, sir.
Honorable Chief Justice. Since the passage with the passage of time, sufficient number of candidates in the cadre of civil judge senior division were eligible to be promoted as district judge through LD. Certain IAs were filed before this court for restoring the set quota from 10% to 25%. So, my lord, it is the experiences that the court has on the administrative.
That
My lord, when it got
such cases that make the law.
I can only say, my lord, when it got reduced, the experience was that you were not getting enough candidates. Today, without any empirical data, my lord, your lordships are being called upon to interpret Article 233 in a manner which, my lord, to us, it's our contention again, my lord, that with respect, that it is going to be a disruptor, my lord, even amongst those who are in service stream, my lord. Last but not the least, my lord, the two judgments, Rameshwar Dayal and Chandra Mohan, my lord, according to me, were on two peculiar facts. Ramesh Dayal dealt with a situation, Rameshwar, my lord, dealt with a situation where advocates who had been enrolled with the Lahore High Court, my lord, whether they could, did they continue to
There are
be
two
on the?
conditions, two eventualities. One, three of them, high courts enrolled in Lahore, whether their experience could be taken into consideration while completing the years of practice at Delhi, and two of them were in service. Mr. Sawhney and Mr.
No, Lord, they were also on the rolls. That's what was shown to you, my lords, yesterday, my lord. Even Sawhney and Harbans. So they continued to remain as advocates. So
That-
that
that is-
distinguishing factor that the petitioners tried
That is
to.
argued, we'll consider
Sorry,
that.
Lord.
Deemed continuation, that's just. They were deemed to be on the role of the bar.
Yes, and therefore, my lord, that is not an authority for the proposition that the petitioners are putting forth. Why? It was a peculiar circumstance.
That is also not an authority to say that the in-service candidates cannot compete in that bar quota.
I'm not saying so, my lord. This is my respectful submission, my lord. I'm not saying Rameshwar Dayal. There are some observations which both sides used and which was noticed in Dheeraj. My lord, would your lordship see the observations in 9.1 which I have extracted from Rameshwar Dayal? My lord? Would my lord just see in the written submissions? Why did the court feel compelled to pass the judgment that it did? Constitution by 9.1, my lord. The peculiar circumstances. What will be the result of interpretation canvassed for and on behalf of the appellant if it is accepted? Then for 7 years, beginning from 15th August 1947, no member of the bar of the Punjab High Court would be eligible for appointment as district judge as a result, which has only to be stated to demonstrate the weakness of the argument. So they said they will continue, and they continued on the rolls, and that was a peculiar circumstance. Now, Lord Chandramohan also, according to me, only dealt with what does in service mean, and they came to the conclusion it is judicial service, my lord. And my lord, rest, of course. My lord, one aspect that I want to draw my lord's attention, my lord, and I end with that. My lord, there was reference to Constituent Assembly debates on behalf of the petitioners, my lord. If your lordship see paragraph 12 of my written submissions, my lord, it's more than well settled in State Bank of Travancore, and this is cited in Keshavananda Bharati, that you cannot, it's not a good external aid for understanding the provisions of the.
Your side also.
Sorry.
That on the some of the councils on your side also refer to the Constituent Assembly debates.
My lord,
Contend that it was only meant to be a bar.
no, it may be so, my lord. We are all trying to assist my lords, my lord, but this is based on the judgment of 5 judges of this court, which is followed in Keshavananda Bharati. My lord, the reason is very simple. They say when you get up in the Constituent Assembly or whoever made the speech, there are others who have not. So you don't know whether they are aligned. Drafting committee report, my lord, is something that you can use as an external aid, not the debates in the Constituent Assembly. It is more than once well settled. I am grateful, my lord.
Thank you. Thank you.
Your lordship's patience.
As I can say, Malos, I start the middle order or maybe the tail end on behalf of the respondents from this side, Malos. I appear in Malos 501.15. Malos, that's the matter Dheeraj Moore versus High Court of Delhi. I represent the Delhi High Court.
You appear for Delhi High Court.
I appear for the Delhi High Court, Malos. Malos, most of the submissions which we had jotted down, Malos, have already been covered. But just for convenience, Malos, so that I can straight away, Malos, tick off. Easy. There are 1 or 2 things, Malos, which I would want to highlight, Malos, which I feel have not yet been covered. Malos, I'll skip 1 and 2 for the meanwhile, Malos. And Malos, I'll come to serial number 3, Malos, because that's been the discussion so far. Rameshwar Dayal and Chandramohan. Malos, it has been, Malos, on this side, Malos, it's been argued that insofar as Rameshwar Dayal is concerned, Malos, it's very clear, Malos, that the ultimate, Malos, the factor, Malos, on the basis of which, Malos, the relief was granted, was the fact that the petitioners continue to be advocates on.
That has been argued.
Yes, Malos. So, Malos, that's the reason, Malos, only in one sentence, Malos. And likewise, Malos, in Chandramohan, the opening phrase has been interpreted to be judicial service. So, Malos, what would be the connotation, Malos, of the fact that Article 233(2) when, my lords, the service, the word service is used as judicial service because that provides an absolute bar in our submission, my lords. My lords, because, my lords, has been advocate 7 years comes subsequently. My lords, 233(2) starts with, my lords, with a bar, my lords, of anyone in the service. And in case that service is interpreted as it's been interpreted, my lords, in Chandra Mohan, that it is a judicial, that it is, my lords, and again, even though the issue, my lords, was so far as judicial officers are concerned, it does say that it's a euphemism. But what has been interpreted is the clause Article 233(2) and the word service. In light of, my lords, how the chapter flows. So, my lords, if 233(2) is service, is judicial service, my lords, then the rest of the part, my lords, does not come into picture. That's my submission, my lords. Now, my lords, and Lordship may see, my lords, serial number.
What is your submission?
My lords, would Lordship kindly have, my lords, 233(2). My lords, when it says, my
You've
lords,
seen it down so many times, you can read.
yes, my lords, just for my benefit, my lords, it says a person not already in the service of the union. Now, my lords, when it's read as service is read as judicial service, it means a person not in judicial service. So, my lords, that's, my lords, where the first, my lords, hurdle has to be crossed. That someone who's either in service or not in service. If
According to you, a person who is in service
Please.
is not entitled under
in
public.
judicial service, my lords, and the reason why, my lords,
So a person who is in some other service is entitled.
my lords, that is, my lords, on the basis of the Constituent Assembly debates, my lords, that's how, my lords, the my lords, Chandra Mohan turns. Because under, if, my lords, 233(1),
Whatever new you want to argue, you may argue, yes.
my lords, I'm saying, my lords, in terms of Chandra Mohan, 233(2) creates a bar on anyone who's in judicial service because the word service is being interpreted as judicial service. What has been the
You are doing total violence to Chandra Mohan.
My lords, may I just, my lords, page 194, if Lordship may have, my lords, volume, my lords, volume 5(1), my lords, would Lordship just, my lords, it's specifically, my lords, it's a word which is used, my lords, that service is judicial service. Page 194, top, my lords, would Lordship just note that. My lords, what has been the subsequent follow-up of that? My lords, it's been argued that it's, my lords, a stay decisis. Subsequent to that, my lords, there is no judgment of your lordships whereby any judicial officer has been permitted to apply under Article 233(2). It was only, my lords, in Satyanarayan Singh which was rejected. The others which have been allowed were all, my lords, advocates as on date. So, my lords, Sushma Suri, Deepak Agarwal, they all dealt, my lords, with those candidates who were appearing as prosecutors, who were actually appearing in the court as lawyers. Even in the two bench judgments, my lords, which have been relied upon, which is Vijay Kumar Mishra, my lords, and Sunil Kumar Verma, which has been Chief Justice Lordship. Para 4.3, as on the date when they applied, they were lawyers with 7 years of service. It is only the hiatus by the time when they were recommended, between the time they were recommended and they ultimately came to be appointed, they joined some other judicial service, lower judicial service. So, my lords, my submission is there is no judgment so far interpreting this this article, my lords, which provides.
So we should not deliver a judgment.
My lords, it is, my lords, the other way around. My lords, if the provision has been interpreted and as construed in a particular way, my lords, that's a submission. That
Keshavanand Bharati ought not to have come. Why should?
My lords, I'll come to that. My lords, if Lordship might have para 5, my lords. Subsequent to 66, my lords, and Lordship may just permit me to make.
Shankari Prasad was appealed in Sajjan Singh. Sajjan Singh was upset in Golaknath. Golaknath was again reversed in Keshavanand Bharati.
My lords, Lordship are correct, my lords.
So law has to be static.
My lords, insofar as the interpretation which does not provide for any other alternative, it's a submission, my lords, that now, my lords, Lordship, para 5, my lords. Subsequent to 66, my lords, judgment, there have been 3 constitutional amendments. My lords, there was, my lords, amendment right immediately after, my lords, which is the 20th amendment. And my lords, article, my lords, 233A was introduced, validating all those, my lords, appointments which had taken place, but were held to be illegal by your lordships. My lords, there was no amendment to the Article 233 per se. It only validated, my lords, those appointments. Subsequently, my lords, with reference to 217, again, my lords, there have been 2 amendments which allows, my lords, the experience of a judicial officer to be, a lawyer can count his experience as a judicial officer and vice versa. But there's been no amendment, my lords, to this section, this article. And that's how, my lords, it's come to be understood. My lords, as also referred to Shetty Commission, my lords, that's been referred to. Shetty Commission itself says that the Constitution does not provide. So, my lords, that lordship may just note, my lords, in 6.2.
Already provided.
Yes, my lords. My lords, there was a query, my lords, which in the morning lordship had raised, my lords, and which had raised right now, my lords. Insofar as, my lords, what is the status of someone who joins the lower judiciary service? Lordship may just note, my lords, Rule 49. My lords, it says that no one shall be a full-time employee of a government and cease to practice as long as he is in such employment. So, my lords, by virtue of that, anyone who joins the lower judiciary, my lords, ceases to be an advocate in terms of the Bar Council of India rules. And this has been noted, my lords, in Deepak Agarwal. Lordship may just note para 83-84, page 741. Deepak Agarwal, my lords, actually goes into this aspect as to someone who's actually, my lords, a government servant or someone who's a pleader or a prosecutor. And what is the implication? Para 83-84, my lords, 83 and 84, page 741, volume Roman numeral V.2.
Yes.
And, my lords, the last submission is when the, my lords, 233 only says lawyer, my lords. By implication, my lords, everyone is, my lords,
Thank you. Thank you.
grateful, my lords, for the opportunity.
I am for the.
I appear in Lord item 1501.26, Lord. I also appear for the High Court of Delhi. So, Lord, we have segregated a time 10 minutes to each, Lord, to make our submission, Lord, good, Lord. Lord, stage pay, Lord, may I invite my Lord's kind attention to the Public Service Commission clauses which have been referred in the volume 2. And this is, my Lord, page number 80 for a moment.
Public Service Commission?
Plus 1920, just to make the submission as to how the lawyers are being considered for the purpose of direct recruitment. If not, just allow me to refer. This is page 80 from the volume 2, volume 4A and volume 4R. Well, this is after the Government of India Act 1915. And I'll just make a reference to section 254 thereafter, Lord. It just let me affirm, Lord, page 80 for a moment. From volume 4A and R.
4A.
Yes, no, this called as volume 4A and R, volume 4R. Roman, sorry.
All that, Lord, the.
Document.
Yes, the 1915 Act, that volume.
Yes.
Very well.
Well, I've tried to read the entire document on this. This is December 1920 document with respect to the appointment of the district judge.
Yes, page?
No, this is running page 80, Lord. And para 2 there in Lord. Lord has that? Page 80, Lord. Para 2 there in Lord.
Government of India resolution.
You know, this Public Service Commission's rules, Lord, that is what they term is this document. As this is a resolution passed by the Government of India as it then was, Lord.
Page 77.
Page, yes, no, it starts from page 77, Lord.
Government of India resolution.
Yes, my Lord. If my Lord is there, my Lord, can I bother, my Lord, with the last one on that page only just to read 2 lines, so therefore I can make my reference. There, my Lord, would find out just before the open competitive exams in examination London, there is a method of recruitment which is given.
How can we go to the 1920
No,
rules
no.
for interpreting the constitutional provision?
Not for that purpose. No, just allow me for 4 or 5 minutes. Lord, I am having 10 minutes time. Only I'll take 3 minutes for this purpose. Lord, try to make my submission now. What I'm trying to say before reading it, I can point out. Lord. At that point of time when 1915 Act was there, Section 254 was standing. Section 254 more or less talks can be seen in Article 233. Please clause
254 is not in 1915 Act, it is in 1935 Act.
I'm so sorry. 1935. I'm so sorry.
And
Yes.
or 1935 Act can't relate back to 1920 rule.
So that can be seen from this rule. Why I'm saying so, this resolution. At that juncture, the Government of India, as it then was considering whether there can be a direct recruitment from the bar. So the Government of India, through this resolution, has come to the conclusion, para 8, page 80, saying this, there has to be 25% direct recruitment as an experimental basis from the bar. This is how it followed. When it followed up to 254, I would say, enactment of Section 254, As it then was, all the Indian civil services were also carrying the judicial services, my lord. So the judicial services were within the Indian civil services. So the subclause 2 of section 254 says, anyone who is in the service of the Majesty will not be considered, but should be a lawyer either in the Scotland or the England for 5 years in practice. This is what exactly it has been borrowed in Article 233 as subject to my understanding. Why I'm saying so, my lord, there is a reason behind it, subject to my lord's kind appreciation. My lord has already had I would say, all the learned senior counsels, my lord. What I'm trying to say, it is with respect to Article 234, which is the subordinate judicial services. There is the Public Service Commission. There is the rules which are to be incorporated. And for that purpose, there is a direct recruitment, not so direct recruitment, it's through the competitive exam. Likewise, when it was to be done in London. So far as Article 233 is concerned, what I'm trying to say, my lord, as has been also argued by almost Sagdar sir, that for the Honorable Supreme Court, for the Honorable High Court, likewise for the District Court, the legislative intent was to get the direct recruitment through the lawyers, or clause 1 is there for the purpose of promotion, and the posting I can ignore it for the purpose of promotion. This is what exactly, in my respectful submission, is borrowed from there. My lord, I borrow one of the observations of Honorable Justice Chandran, and I also follow the same with respect to Chandar Mohan. My lord, my side may say that I'm arguing from the other side, but what I'm trying to say, when Chandar Mohan was being considered, in the Chandar Mohan judgment, the Honorable Supreme Court has considered, and a particular line has been used. At that particular time of our country, as my lord, Honorable Justice, Chief Justice has referred, that law cannot be static. I also follow the same. That at that point of time, the magistracy was not only disposing taking the judicial action, it was also considered revenue action, the other administrative action. This is what exactly has been used in the Chandar Mohan. So this Honorable Court in Chandar Mohan was of the view this should be excluded. Therefore, only the judicial service has been incorporated for this very purpose. If we go by this interpretation as has now been projected by the petitioner's side, my lord, if I be simply go by the same for a moment, take it like that I'm arguing from the other side, my lord, but just subject to the convenience and the balance and the equity, and also Article 14. What I'm trying to argue on this, my lord, then in that case, not from the first All India Judges cases, which is based upon the Honorable Justice Sethi's Commission, my lord, going up to the 5th judgment of the Honorable Court, my lord, that is not required then. Simply, Sita, because that Justice Sethi's Commission's report is based upon this very, I would say, principle, that there is a direct recruitment from the bar, and there is a promotion, there is a LDC, and for that purpose, there can be other avenues.
For experimental basis by increasing the number of.
Yes, I follow, Lord. This is what exactly I'm saying.
How did we get it?
Lord, what I'm saying, Lord, if Lord may allow me,
Yes.
just I think 2-3 minutes left, Lord, just for this very purpose. What I'm trying to argue, Lord, on this as well. In that sense, my lord, if this Honorable Court come to the conclusion that judicial service should not be excluded from Article 233(2) for the purpose of interpretation of Article 233, I follow the suit for a moment. Then in that case, a new commission should be appointed. Then there should be a different research on this point, that whether there's how much promotion should be done, how much LDC should be done, and there should be direct recruitment.
Yes, thank you, thank you.
Just, my lord, two submission on the lighter note, my lord, just on that competency part, as my lord has pointed out. Honorable Justice Sandres has also pointed out, only on that, my lord. If a judicial officer appears in the higher judiciary exam, for a moment, my lord, I'm so sorry, but please allow me. Just, my lord, I'll not take more than 1 minute. If a learned judicial officer, I use the term learned judicial, appear in the competitive exam with the lawyers who are also competing with him, being considered having vast knowledge, and fails in that exam, whether his career, at least in the eyes of the common person, is not causing disruption, because that he is not able to pass the higher judicial exam, but after 2-3 years, let him be promoted, become a district judge. Lord, I'm just on the lighter note. But
Thank you.
This is not logic.
no, I'm just saying, Lord, and so far 35 years is concerned, Lord, as my Lord was observing. For the lawyer to compete in the to appear in the exam, the age is 35. Generally, the lawyer, the young student become a lawyer at the age 23, 24. So still 12 years is required. And so for the purpose of now with the Honorable Court decision, that 3 years as a pre-experience, then 7 years, it goes to 10 years, 11 years. So the age is almost equal. So it's a, I would say, fair play field for everyone. This is my responsibility.
That you are arguing in,
Lord, I'm saying, Lord, for the lawyers, at least, Lord, let them also be on the fray. Let the best, I would say, merit may come on to decide the cases. There is no dispute to that, Lord. For that purpose only the LDC was created, my lord, I would say. I am so obliged.
Thank you. Next is on Mr. Azam.
My lords.
You are appearing for whom?
Much has already been covered. I am representing in 501.15 and 0.26, my lords.
For whom?
For Rochak Bansal. Rochak Bansal.
Who is Mr. Rochak?
He has filed a review petition and he is actually affected by Dheeraj More and he was a candidate in an examination in
You are
Punjab.
on this side then.
No, my lords. He is not the judicial officer. He is not the judicial officer. He is an advocate.
But how is he affected by Dheeraj More?
Because he was in a waiting list and an officer, the judicial officer got selected for the loan seat that was advertised and he was the loan.
We'll consider separately, yes.
Yes.
This will consider separately.
Individual matters will be considered.
A very short submission. Much has already been covered by Punjab and Haryana High Court's representation balance. What we are saying is in service actually bars the candidates who are judicial officers for the simple reason is that yes, they are covered under Article 235 for the insulation of the independent function as a judge performing their judicial duties. However, for the purposes of salary, remuneration and everything else, their funds are derived from the consolidated funds of the state and the union, and therefore that relationship of the master and servant remains with the state and the union, my lords. My lords. Grateful.
You are appearing for Bombay High Court.
My lords, yes. So that is item 501.12.
Yes.
My lords, may I just request your lordships to come to my written submissions, which are in volume 2, Roman 2, page 160 is the relevant page. So, my lords, almost everyone.
It's pointed out. What made you to take a different stand now?
Come to volume 7, page 656.
Better you don't say.
Volume 7, page 656.
Just because, see, Deepak has come. So therefore you implemented it on the basis.
The registrar legal, who must have drafted this affidavit, must have been from the direct recruit.
That's why, my lords, I was requesting.
We'll have to observe what your contradictory stand. So come to page 656.
My lords.
What is the stand taken by you before this Shetty committee? Volume 7.
There's no volume 7. No volume 7. It could be something else.
High Court, you should have faith. It's only you who have to have more faith in your officers who are working under you, not voting for the lawyers. Just to defend the rule. You can simply say, all right, we followed the law at the relevant point of time by the High Court to frame the rules.
It's volume 4, sorry, volume 4.
My lords, yes, my lords, I'm looking at volume 4 only.
Volume 4, page 653. Para 11.52.
My lords.
That would equally apply to Nidesh Gupta.
That's true.
Not true.
Yes, anyway, what are your arguments now? Tell us.
I've seen this, my lords. I've seen this, my lords. But that is why, my lords, I was requesting.
At that time, the registrar legal who must have drafted the affidavit must be from the promoting category, and now the registrar legal who has drafted this affidavit must be directly appointed.
Rather, may I say, my lords, maybe the mode of recruitment also
They are anxious to
perception.
preserve the rule and status quo. Very well.
That's why, my lords, may that be also reason for change in perception. May I just request your lordship's attention to page 160, volume 2. I won't take much time, my lords.
Page
160, volume 2
of your written submission.
of my written submissions, my lords.
Yes.
As well as everybody else has also, all my learned colleagues and senior colleagues have brought your lordship's attention to the Article 233.
Page?
Page 160, it starts at 157. But may I request your lordship's attention to page 160? And was the only one expression which I would like to beseech your lordships to is in clause 2 of article 233. My lords, the Honorable Chief Justice has, my lords, page 160.
Yes. If we have.
My lords, yes. My lords, may I just read this? Clause 2. A person not already in the service of union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Now, my lords, my emphasis would be on the expression only, which appears in the second line of this clause. But what fell from your lordships time and again is whether the language of article 233 or clause 2 is restrictive. So my lords, our submission there is that the language is restrictive since it employs the expression only. Now with this background, may I request your lordship's attention to page 167 of this very note, where we have tried to explain, that is paragraph number 21. May I read more paragraph 21, page 167. The distinction between these two sources has been emphasized by the Constitution Bench in Chandramohan 1. The court held that Article 233(1) is intended to govern appointments of persons in judicial service, that is by way of promotion in consultation with the High Court. Article 233(2), on the other hand, specifically contemplates appointments from the bar and uses a restrictive word only. This expression excludes all other classes of...
Argued by everyone.
We'll consider.
My lords.
Anything you want to argue, you may submit.
Subject to correction, probably your lordship's attention to this clause expression only was not brought to
Yes.
my lords. Sorry. My lords, then may I request your lordship's attention?
In Supreme Court, the lawyers are not present at all the time, so they don't know what is argued by the others.
That is too much for. Anyways, may I request your lordships to the another expression that the explanation that we have given in paragraph number 28, my lords.
Nobody, this is not the issue.
Because otherwise, my lords, the yes. Para 28. Turning to the fourth question, it is necessary to examine whether a person who has partly served as a civil judge and partly practiced as an advocate for a combined period of 7 years can claim eligibility under Article 233(2). The plain text of Article 233(2) provides the answer. It uses the expression, a person not already in service of the union or the state shall only be eligible. Now, I'm pausing here for a moment to meander. The consequences of inclusion of those who are already in judicial service from the bar quota will have its own cascading effects, because a person who is already in bar is not permitted to compete or appear from the judicial services category.
How can that be?
Not yes.
We are arguing something which is totally unknown to the service jurisprudence.
No, certainly now, my lords, therefore,
High Court or Bar Association?
no, my lords, therefore, my lords, in our humble submission for
What is this?
inclusion.
Sorry, it's an
May I just formulate? My lords, may I just formulate? My lords, may I just formulate? Permitting, my lords, suppose, my lords, tomorrow the officers of the judicial service are permitted to compete from the bar quota. My lords, it is not reverse applicable. There is no reverse osmosis applicable here. Then, my lords, in that case, it would also amount to the reverse.
Are you arguing with seriousness?
Alright,
Sorry, my lords, but then this is our stand specifically mentioned in paragraph number 22, 23 onwards.
Thank you.
My lords. So I raise my case, my lord.
Yes, Mr. Sindhu Rao.
Please, Minutes. I'm appearing in 501.11 minutes. I'm appearing for the High Court of Telangana. Minutes. My written submissions are at page 115 of volume 2 minutes. Much has been argued, my lords. I'll only bring to your lordship's attention 3 points, my lords, which have not been addressed before your lordships. The first point, my lords, is with respect to the principle of constitutional silence. My lords. It's a given fact, my lords, that in any written constitution, there are certain silences which are on purpose left there, my lords, certain deliberate omissions. This is, my lords, the submission is with respect to question number 4 before your lordships today, where the explanation is specifically given in 124 and 217 And under 233, the constitution framers left that silence, my lords. That is not to be filled up before your lordship. Before your lordships may kindly have, my lords, one judgment, Manoj Nerula, my lords, which is, my lords, at page volume 5.3, my lords, page 778.
Volume?
5.3, my lords.
Page?
The judgment starts, my lords, at page 778. The relevant portion that I would like to point out to your lordships is at page 829, my lords. Para 54 to 56, my lords, of this judgment. It's a constitution bench judgment, my lords. This judgment, my lords, was in respect of disqualifications regarding to MPs and MLAs, while looking into a constitutional silence with respect to another disqualification which was sought to be added. This honorable court, by way of a constitution bench, held that that silence would not be filled up, my lords.
Page 7.
Page 829, my lords. The judgment starts, my lords, at page 778. Relevant portion, my lords, at page 829. May I read, my lords? Para 54. The next principle, lordships have it.
Yes.
The next principle that can be thought of is constitutional silence or silence of the constitution or constitutional abeyance. The said principle is a progressive one and is applied as a recognized advanced institutional practice. It has been recognized by the court to fill up gaps in respect of certain areas in the interest of justice and larger public interest. Liberalization of the concept of locus standi for the purpose of development of public interest litigation to establish rights of the haves-nots and to prevent damages and protect the environment is one such feature. Then, my lords, lordship may have para 55, my lords. In this context, it is profitable to refer to the authority in Bhanumati versus State of Uttar Pradesh, my lords, wherein this court was dealing with the constitutional validity of the UP Panchayat Laws Amendment Act 2007. One of the grounds for challenge was that there was no concept of no confidence motion in the detailed constitutional provision under Part 9 of the Constitution. Therefore, incorporation of the said provision in the statute militates against the principles of Panchayat Raj. In that, my lords, in the judgment of Bhanumati, which has now been recognized by the Constitution bench, my lords, the next page, my lords, at page 830. Bhanumati is quoted, my lords, para 49 and 50. If I may read, my lords. Apart from the aforesaid reasons, the arguments by the appellants cannot be accepted in view of a well-known constitutional doctrine, namely the constitutional doctrine of silence. Michael Foley, in his treatise on the silence of constitutions, has argued that a constitution abeyances are valuable, therefore, not in spite of their obscurity, but because of it. They are significant for the attitudes and approaches to the constitution that they evoke, rather than the content or substance of their strictures. The learned author elaborated this concept further by saying, despite the absence of any documentary or material form, these abeyances are real and are an integral part of any constitution. What remains unwritten and indeterminate can be just as much responsible for the operational character and restraining quality of a constitutional as its more tangible and codified components. Going further, my lords, at para 56, which is the most important part of this judgment, my lords, the question that is to be posed here is whether taking recourse to this doctrine for the purpose of advancing constitutional culture, can a court read a disqualification to already expressed disqualifications provided under the Constitution and the 51 Act? The answer has to be in the inevitable negative, for there are express provisions stating disqualifications, and second, it would tantamount to crossing the boundaries of judicial review. In the present case before your lordships, my lords, specifically, the explanations under 124 and 217 have not been consciously and deliberately not been included within 233 minutes. In fact, my lords, the learned senior for the petitioners, my lords, has argued that the explanation under 217 does not refer to advocacy experience before holding a judicial office, but only refers to the one after, so it would not. But that, in fact, would inure to my benefit, my lords. Even under 217, any advocacy practice before holding of judicial office is not being counted. So any clubbing to that respect, my lord, in my respectful submission, ought not to be taken. The second point, my lords, that I would like to make is with respect to, my lords, the necessity for the direct recruitment and a quota. As lordships have already seen, right from 1920, there has been a quota which has been 1/4 for bar members. That, my lords, in fact, has also been specifically noted by the Law Commission report, my lords, in, if your lordship may have, volume 4R, my lords. The Law Commission report specifically says that direct recruitment from the bar is necessary to infuse fresh and young blood, my lords. So this one point, my lords. One alternative submission, my lords, which I would like to place before your lordships, is that even, I'll take it against myself, my lords, that even if your lordships are to hold that 233 does not today prevent in-service candidates from being eligible for direct recruitment, the language of 233(2) is very clear, my lords, that the experience of 7 years of advocacy is not applicable for in-service candidates. Any eligibility which now has to be formulated, my lords, can only be prospective. Any such eligibility, my lords, cannot be in a retrospective manner read into 233. These are my submissions. I'm extremely grateful for the opportunity.
Yes, Maharaj, I am appearing for the State Bar Council of Madhya Pradesh, Maharaj. That is IA intervention number 24074.
So I appear for Allahabad High Court, my lords.
So who is Mr. Yashovardhan?
Yes, Sam. So I appear for Allahabad High Court. I adopt the submissions of Mr. Nilesh Gupta, my lords, squarely, because that covers, my lords, entirely our cases.
Very good, very good. Okay. Yeah, appreciate your question.
In fact, it's complicated, my lords, Mr. Nilesh Gupta to clarify.
Lords, I am for the intervener, my lords, State Bar Council, Madhya Pradesh. This is IA number 240746 of 2025, my lords. We had helped to trace out the copy. My lords, I have prepared short written submissions also, my lords. May I just pass on, my lord, along with, so that's it. My lords, first, my lords asked a query in the morning, my lords. I apologize, I was not here. I was on legs before another court, my lords. My lords asked a question about what happens if any person, any advocate is selected as the judicial officer. My lords, and what's the practice in Madhya Pradesh or State Bar Councils across?
So what is the provision in the law?
Yes, my lords. So there are, yes, my lords. In my intervention, my lords, I have filed the Bar Council of India rules, my lords. The Bar Council of India rules, my lords, please come to them, rules 43 and 49. I'll just read them. But before that, I'll point out 43 requires, my lords, that immediately I take up any profession, calling, vocation, my lords, which is inconsistent with my practice. I have to intimate by way of a written application to the Bar Council, the State Bar Council, on the basis of which, in view of 49, my lords, and read with section 35(4), I'll read that. It stands suspended, my lords. The license stands suspended. So that takes me, my lords, to the provision. My lords, may please come to page.
Documents are not part of the convenience compilation.
Yes, my lord. We filed on Saturday, my lords.
We will have to just wander from here to there. Could have been.
IA is not part of compilation, but part of record, my lords. We helped in tracing out yesterday, my lords. We gave.
Should have given whatever documents you wanted to, so that they could have been a part of compilation.
Yes, my lords, I received the instructions on last Thursday, Friday, my lords, by which time the compilation.
Why should we hear you? You are not diligent enough.
My lords, I apologize. It came to me and within 48 hours.
We don't know when it came to you or not come to you. Why should we inconvenience also?
This
As it is with so many voluminous documents.
The intervention application we helped in tracing out yesterday. We gave it.
It should have been diligent if they wanted. The matter is pending since long.
So I'll just read out those provisions in the meanwhile, my lords, as they are searching, my lords. I'll just read out because at least the position of law may be clear. My lords, these are BCI rules. Rule 43 says an advocate who has been convicted of an offence mentioned under 24A of the Advocates Act or has been declared insolvent or has taken full-time service or part-time service or engages in business or any vocation inconsistent with his practicing as an advocate or has incurred any disqualification. Disqualification mentioned in the Advocates Act or the rules made thereunder shall send a declaration
to that effect to the respective state bar council in which the advocate is enrolled within 90 days from the date of disqualification. If the advocate does not file the said declaration or fails to show sufficient cause for not filing such declaration, provided the committee constituted by the state bar council may pass order suspending the right. This is rule 43, which makes it mandatory for any person departing from the profession in any manner, digressing for any reason, any other profession, to intimate, my lords. And then, my lords, rule 49, which was read out by my learned senior few in the first half. Rule 49 says, an advocate shall not be a full-time salaried employee of any person, government, firm, corporation or concern, so long as he continues to practice, and shall, on taking up any such employment, intimate the fact to the bar council on whose roll his name appears, and shall thereupon cease to practice as an advocate so long as he continues in such employment. That then there was a resolution which was adopted in 2001, which said, resolution number 156 quoted in this only. The IA is before, my lords. I am reading page 86 of the IA. Rule 43, which I read out, my lords, is at page 81. Page 81, which I read out. And 49 is at page 86.
Which rule?
43.
43.
43, initially I read out at page 81 of the BCI rules. This is downloaded from the official website. Purportedly, and to my understanding, must be an updated document. It 86. 86, which fell for consideration in the judgment of Sushma Suri and Deepak Agrawal, which were referred to by my learned senior, my lords, is 49, rule 49.
Oh.
So essentially, my lords, rule 43 perhaps were not looked into in Deepak Agrawal, which casts a duty, obligation mandatorily on the lawyer concerned himself to intimate within 90 days. So my instructions are, my lords, that a person, when he takes up the post of judicial officer, it gets suspended till the duration he serves on the post. And if he resumes practice, say after retirement, like district judges choose to practice in the High Court, before the High Court, after retirement, my lords, then it gets resumed. Institution.
If you intimate, only restriction from practice, not even suspension.
The suspension is punitive.
That's
Yes.
what.
If it is not
So
intimated,
in the rules, you can't practice.
we can't practice. But section 35 of the Advocates Act, 35(4), which we have quoted in the intervention, my lords, may just see in the intervention we have quoted. Where an advocate is suspended from practice under clause C of subsection 3, he shall during the period of suspension be debarred from practicing any court or before any authority or person in India. So, though word suspension is used, so if the person intimates under rule 43 read with 49, then under the rigors of 35(4) as interpreted in Deepak Agrawal and Sushma Suri, he is debarred from practicing. That's the necessary obvious outcome. Then I just 4-5 points, my lords. Quickly in 5 minutes, I'll sum up, my lord. Chandra Mohan has been read again and again. One thing which I would like to read, my lords, is Article 236, Clause B, which is the definition of judicial service. It says the expression judicial service